Hello students. So this is an intro video to a quick revision marathon of corporate and other laws CA Inter. And this quick revision marathon is applicable for Jan 25 exam onwards. And the total duration of this quick revision marathon is approximately 12 hours. Right now I'm not releasing a 12 hours video. So I'm releasing this quick revision marathon in 3 parts. Part 1 consists of incorporation, prospectus, share capital, deposits, charges. Incorporation weightage is 6 marks, prospectus weightage 6 marks, share capital weightage 8 marks, deposits average weightage is 5 marks, and charges average weightage is 5 marks. So total you can expect 30 marks from this part 1 of quick revision. And the speciality of this quick revision marathon, in this quick revision marathon I'm using a handwritten notes. So this is a handwritten notes, yes, complete notes written by me. These handwritten notes consist of all the concepts that are covered in study material, and I covered almost all the points of each and every concept. And trust me, by reading these handwritten notes and by listening to this quick revision marathon, you can attempt maximum marks. Even MCQ's preparation is sufficient with this quick revision marathon. So this is a quick revision marathon notes prepared by me, and this is also available on website. So you can download this document and you can read it. And the moment you complete each and every chapter, so don't watch next chapter immediately, go with CA Inter Law Question Bank, and this is also a free resource available on our website. So here the speciality of this question bank, it consists of study material questions, it consists of RTPs, MTPs, and previous examination question papers also. So when you complete this quick revision marathon video and then after preparation, after solving these practical questions, trust me, you feel confident in attempting the upcoming exams. So this part 1 is of having, total duration of part 1 is 4 hours 10 minutes, and I will release part 2 within a week, and I will release part 3 of this quick revision video by the end of this month. Okay, so stay tuned and watch marathon. So in this lecture I'll revise with you chapter 2, incorporation of company and matters incidental thereto. So total 20 sections are there in this chapter. So starting with section 3 ends with section 22. First of all, it is important to have an idea about formation of company. For formation of company, 2 documents are important, MOA, AOA, and these 2 documents, MOA, AOA, shall be prepared according to the provisions of Companies Act. Once documents are ready, proceed with incorporation. In addition to incorporation, if you obtain license from central government, then you will be treated as company with charitable objects. Then what is the effect of incorporation? What are the effects of MOA, AOA? So section 3 to section 10. Next one, commencement of business. For commencement of business, we should have a registered office. Entrance of registered office, we should have a name board. And that name will be changed either voluntarily by company or compulsorily due to order of central government. Any change to name requires alteration to MOA, alteration to AOA. Every time when you alter MOA, AOA, you have to make a note of it. Alteration to be noted. Next one, company documents. Company documents, copies of documents, companies 2 types, conversion, subsidiary. Documents, copy of documents, service of documents, signing of documents. Now section number 3, formation of company. 3A, minimum number of members. Section 4, MOA. Section 5, AOA. Section 6, Act is having overriding effect. Section 7, incorporation. Section 8, formation of company with charitable objects. Section 9, effect of incorporation. Section 10, effect of MOA, AOA. Section 10A, commencement of business. Section 11, omitted. Section 12, registered office. Section 13, altered MOA. Section 14, altered AOA. Section 15, alteration to be noted. Section 16, compulsory change of name or rectification of name. Section 17, copies of documents. 18, conversion of companies. 19, subsidiary, not to hold shares in holding company. 20, service of documents. 21, authorization, authentication of documents. 22, execution of bills of exchange. Clear? So first one, section 3, formation of company. Yes, a company can be incorporated for any lawful purpose. For private limited company, minimum 2 members are required. For public limited company, minimum 7 members are required. And for OPC, minimum and maximum number of members is 1. And then you'll be given three choices, whether you want company limited by shares or company limited by guarantee or unlimited company. You can select it. In case of limited by guarantee and unlimited companies, again 2 options are there, either with share capital or without share capital. So total we are having 5 types of companies with respect to liability of members. One is limited by shares, limited by guarantee with share capital. Next one, limited by guarantee without share capital, unlimited company with share capital, unlimited company without share capital. Clear? Next one, this number of members, minimum number of members, 2 in case of private, 7 in case of public company. This condition to be satisfied not only at the time of incorporation, but also subsequent to incorporation. As long as company is carrying business operations, as long as company is carrying any activities, company minimum it should have 2 members in case of private limited, 7 in case of public limited. In case of fall in number of members below statutory limit, that means in case of private company below 2, in case of public company below 7, then what will be the consequence? Let's see. Condition 1, fall in number of members below statutory limit. Condition 2, company carries business for a period exceeding 6 months, and members who are aware of this fact that company is carrying business operations with a reduced number of members, those members shall be liable severally, jointly and severally, for the debts contracted after expiry of 6 months from the date of reduction of members. Understood? It's not from the date of reduction, it's from 6 months, after expiry of 6 months from date of reduction of members. That is all about section 3A. Next one, section 7. So what are the documents we need to file for incorporation of company? First one, duly signed MOA, AOA. Next one, declaration of compliance. So who signs declaration of compliance? One professional and one director or manager or secretary involved in incorporation of company, participated in incorporation of company. And this declaration is all about compliance of Companies Act and rules made thereunder. Proposed company's incorporation was according to the provisions of Companies Act and rules made thereunder. Next one, another declaration. This declaration shall be signed by each and every subscriber and first directors of the company. This declaration is all about, we have not convicted any offense in the formation, incorporation, promotion or management of any company during last 5 years. And we have not been found guilty of offense breach of duty during the last 5 years in any company. Next one, proposed company incorporation. Yes, we have filed correct and complete documents. So covering these 3 matters, subscribers and first directors of company shall sign a declaration. Next one, details of directors, details of subscribers, written consent of directors to act as a directors in the proposed company. Next one, interest of directors in other body corporate. So this information they need to provide. And last, address for temporary correspondence. So when you file all these documents with a ROC having jurisdiction, where you are getting incorporated, where you want to set up registered office, you need to file documents with ROC having the jurisdiction. Now ROC, after verifying adequacy of documents, I'm using the word adequacy, it's not accuracy, adequacy of documents, ROC shall issue certificate of incorporation. And certificate of incorporation is a conclusive evidence that company was incorporated. Company came into existence by complying all the provisions of Companies Act 2013 and rules made thereunder. Now whatever documents you prepared for incorporation of company shall be preserved at one place. That place is registered office till liquidation of the company. Understood? Everyone. Next, details of subscribers. If subscriber is an individual, you need to submit these details, name, photograph, father name or mother name, nationality, proof, date and place of birth, educational qualification, PAN, email ID, mobile number, address and address proof of identity also, I told you, right? Next one, in case of body corporate as a subscriber, so here we need to submit these details, name of the body corporate, SIN, GLN, SIN, corporate identity number, GLN, global location number, email ID, registered address of body corporate, place of business of body corporate. If body corporate is a company, then certified copy of board resolution authorizing a director to sign MOA on behalf of body corporate. Next one, in case of subscriber LLP, then certified copy of partners resolution. In case of foreign company or a company incorporated outside India, we need to mention, we need to disclose certificate of incorporation details and its registered address. Clear? Everyone? Next one, signing of MOA and AOA. Just signing MOA, AOA alone is not sufficient. In addition to signature, you need to add your details. That means name, address, description, occupation. Along with that, one witness has to sign against each and every subscriber. One witness for all subscribers or one witness for one subscriber is also allowed. Next one, in case of illiterate subscriber being illiterate, so he or she affix thumb impression. Down the thumb impression, we need to add details. Understood? And person adding those details, he has to sign as a witness. Understood? Next one, body corporate as a subscriber, authorized director or officer or employee of a body corporate shall sign MOA of a proposed company. Next one, in case of foreign national as subscriber, a foreign national wants to become a subscriber of a company or wants to become member of company. In that case, he need to disclose business visa. He need to attach business visa document and notarized proof of identity. Understood? So for some countries, notarized proof of identity. If a country, he belongs to a country which is member of Commonwealth or Hague Apostle Convention, notarized document is sufficient. Notarized proof of identity is sufficient. For remaining countries' citizens, I told you the document should be notarized by consular, diplomatic consular. Yes or no? I told you. Next one, this is all about signing of MOA and AOA. Next one, furnishing of false information or suppression of material facts. So the documents you are filing with ROC, in these documents, if there is any incorrect information or if there is any suppression of material facts, then what are the consequences? We need to check whether company was incorporated or not. Suppose company not yet incorporated, sir, then person who filed application will get punishment under section 447. Suppose company incorporated, sir, then default person responsible for such defaults will get punishment under section 447 and company will also get punishment. Who will punish company? NCLT. NCLT can pass any of these 5 orders, any of these following 5 orders. First one, it may order for change in MOA or AOA. It may order for conversion of members limited liability into unlimited liability. It may order for removal of name from register, or it may order for winding up of company, or it may pass any other order as it thinks fit. But before passing any order, it will give one opportunity of being heard, and it will also consider all the transactions that happen till the date of passing order. Clear? Who will consider all these transactions? NCLT. Correct. Next one, one person company. This is also part of section 3. In one person company, we will find how many persons? Only one person, one member. In case of, in the event of incapacity of a member or in case of death of the member, who becomes member of one person company? Nominee. Now this member and nominee should satisfy certain conditions. Those conditions are, he should be citizen of India. He or she should be citizen of India. Natural person, resident or otherwise. The third condition is resident or otherwise is there. But there one point is there. Even if his period of stay in the preceding financial year is 120 days or more, then he is eligible to act as a member. He is eligible to act as a nominee of one person company. Understood? So third condition, period of stay, if it is at least 120 days in the preceding financial year, he is eligible to become member of OPC. He is eligible to become nominee of OPC. Can a minor be appointed as nominee of OPC? Can a minor be appointed as a nominee of OPC? Answer is no. Next one, maximum a person can become, a person can become member in one OPC and the same person can become nominee in another OPC. Understood? Suppose, sir, I am member of my OPC, I am also nominee in another OPC, and in that another company, that member got deceased. Now because of my nominee-ship, I automatically became member in that OPC, sir. Now in this situation, I am holding membership in how many OPCs? 2 OPCs. So here, corrective action should be taken within how many days? How many days? So within within 180 days, I should make corrective action. That means I should liquidate one company. That means I should come out of one company. Clear, everyone? Next one. With respect to company, there are some conditions. There are certain conditions. What are those conditions? Company is prohibited from carrying Section 8 activities. One-person company is prohibited from carrying NBFC activities. One-person company is prohibited from carrying investment in body corporates. So before naming someone as a nominee, a written consent, it is very important to take written consent of the nominee, and we need to file that written consent with ROC. Next one, sir, in how many situations vacancy arises in nomination position, sir? In 3 cases. What are those 3 cases? Suppose a nominee is withdrawing his consent, or member wants to remove nominee, or member got deceased, or member became incompetent to enter into a contract, for example. So in these 3 cases, nominee, vacancy in nominee arises. Yes or no? Yes or no? So within 15 days of vacancy, appoint new person as a nominee, and within 30 days of vacancy, communicate the same with ROC. Next one, benefits available to one-person company, not required to prepare cash flow statement. And financial statements, who will sign financial statements? One director signing financial statements sufficient. Annual return, company director signing annual return sufficient. AGM not necessary. Board meetings not necessary. And what is the due date for filing financial statements with ROC? 180 days of closure of financial year. For all other companies, filing of financial statements with ROC, the time limit is 30 days from the conclusion of annual general meeting. I told you this point also. For all other companies, within 30 days of general meeting, company has to file financial statements with ROC. But for one-person company, general meetings are not necessary. So financial statements shall be filed within 180 days of closure of financial year. This is all about one-person company. Next one, Section 8, formation of company with charitable objects. So yes, a company can be formed for carrying charitable activities also, but for that it should satisfy certain conditions. So what are those conditions? In memorandum of association of Section 8 company, the objects must contain SARC objects, that means social welfare, science, art, education, environment protection, research, charity, commerce. Clear? And Section 8 companies are prohibited from declaration and payment of dividends. Whatever surplus is there in Section 8 company, invest that surplus in promoting other objects of the company. Clear? Everyone. Now just file an application for registration. Attach the following documents for getting license. What are those documents? MOA, AOA, estimates of incomes and expenditure for the next 3 years, and declaration of compliance. So we complied all the provisions of Companies Act 2013 and rules made thereunder for getting license from central government in order to treat us as Section 8 company. Clear? Next one, privileges. Section 8 company will also enjoy all the privileges as if it is a normal company, as if it is a other kind of company. So benefits of Section 8 company: for calling general meeting, 14 days notice is sufficient. 14 days notice means what? Every day they should give notice for 14 days. No, the time gap between date of notice of meeting and meeting, 14 days is sufficient. For other companies, 21 days. Next one, no requirement of minimum and maximum number of directors, no requirement of committees of directors. Next one, even a partnership firm can become member in Section 8 company. Next one, Section 8 companies are not required to use words private limited or limited in its name clause. Next one, revocation of license. On what grounds license can be revoked? On what grounds license can be revoked? So what are those grounds, ma? Contravention of Section 8 of Companies Act 2013. Contravention of conditions specified at the time of giving license. Next one, carrying affairs fraudulently or carrying affairs which are opposed to public policy. In all these 4 cases, authority, after giving one opportunity of being heard, authority revokes license. After revocation of license, authority may order company to get it amalgamated with similar Section 8 company. Similar Section 8 company means Section 8 company with similar objects, or it may order for winding up of company. In case of winding up, Any surplus resulting from winding up shall be transferred to insolvency and bankruptcy fund. Clear? Everyone. In addition to revocation of license, you will also get punishment. So what is the punishment, sir? In case of company, in case of defaults, for company, minimum 10 lakhs, maximum 1 crore. Equation ma. 10 lakhs less than or equal to, penalty less than or equal to 1 crore. Equation. To remember easily, just I framed equations. Next one. For OID, OID means officer in default. Minimum punishment 25,000, maximum 25 lakhs. And if the affairs of Section 8 company were conducted fraudulently, then officer in default, officer responsible for the default will get punishment under Section 447. And I told you one example. Suppose I incorporated Section 8 company to carry money laundering activities, converting black money into white money. So if I use Section 8 company for this purpose, that means, I'm using company, I'm carrying activities, I'm carrying affairs of a company in fraudulent manner. So now I'll get punishment under Section 447. And I told you punishment, punishment is minimum amount involved in fraud, maximum 3 times of amount involved in fraud. Clear? Everyone. Next one, procedure for conversion of Section 8 company. Procedure for conversion of Section 8 company. First one, special resolution we need. Next, file an application with authority. Here authority is regional director. Along with application, attach following documents. One is certified copy of special resolution, notice of meeting, explanatory statement. Explanatory statement. Next one, proof of notice served to authorities, various authorities. Here various authorities means Chief Commissioner of Income Tax Officer, Charity Commissioner, Chief Secretary of State. Next one, any department or organization under which Section 8 company is getting operated. So you need to serve notice to all these authorities, and yes, I serve notice to all these authorities. Like that, you need to attach a proof of notice. Simply, postal acknowledgement is also sufficient. Postal acknowledgement is also sufficient. And next one, publication of notice in 2 newspapers. One is in vernacular newspaper, other one is in English newspaper having wide circulation. Clear? Now, these authorities, Chief Commissioner, Income Tax Officer, Charity Commissioner, Chief Secretary of State, any person, they can make representation within how many days of receipt of notice? 60 days. If there is no representation from these parties within 60 days, then regional director will make an assumption that there is no objection from these parties, and regional director will proceed with the conversion. Regional director will issue an order for converting Section 8 company into other kind of company. And you can see ROC filing, publication of notice. Next one, compliance with filings. So before regional director issuing an order, regional director ensures that company has filed all relevant statutory forms with ROC. So here statutory forms, nothing but financial statements, annual returns. Suppose from the date of application, preceding financial year closure date and date of application, if the time gap between these 2 dates is more than 3 months, then you need to prepare financial statements for that period, for that additional period, and that financial statement shall not be older than 30 days. Getting my point, students? Everyone, financial statement shall not be older than 30 days. Next one, regional director will pass an order. That means, he may confirm conversion. Once regional director approval is obtained, conduct general meeting, pass special resolution for amendment of MOA and AOA, and file all these documents with ROC. ROC shall issue fresh certificate of incorporation. So here, after your name, words private limited or limited will be added. Clear? Everyone. Next, section 8 also completed. Next one, section 9, effects of registration. From date of incorporation, when? From date of filing of application or from date of incorporation? Date of filing an application with registrar or date of incorporation? Date of incorporation. From date of incorporation, company will get following characteristics. It will get body corporate status. It will have perpetual succession. It can acquire properties, hold properties, dispose properties. It can enter into contracts, it can sue, it can be sued. And subscribers to memorandum of association becomes members of company. Clear? So these are the effects of registration. Next one, Memorandum of Association, section 4. In section 4, we are having total 7 subsections. Subsection 1 is all about details in MOA, clauses, name, situation, object, liability, capital, association. Subsection 2 and subsection 3 speaks about restrictions on name. Name shall not be identical. Name shall not be resemble with the name of existing body corporate, and name shall not be undesirable in the opinion of central government. So subsection 2, subsection 3 talks about restrictions on name, and subsection 4 and subsection 5 talks about reservation of name, whether proposed name available or not. For that we file a form with ROC, and what is the applicable fees? 1000 rupees. And who is filing that form is important. Proposed company. Sir, we are filing application for proposed company. The name shall be reserved for a period of, come on, name shall be reserved for a period of 20 days. Sir, existing company, it wants to change its name. Existing company is planning to change its name. Now existing company is filing a form with ROC to verify whether name is available or not, to ensure whether name is available or not. If name is available and if name is reserved, it can be reserved for a period up to 60 days. Okay, everyone. In case of any, in case of any incomplete information or in case of any defects in the form, registrar will give 15 days time period for rectifying those defaults and for resubmission. Clear, everyone? Now, when you furnish false information for reservation of name, what are the consequences? Suppose if company not yet incorporated, then reserved name shall be cancelled and applicant will get punishment up to how much? 1 lakh rupees. Next one, suppose company was incorporated, sir. Company was incorporated by furnishing false information at the time of reservation of name. In that case, registrar may strike off your name, that means removal of name, or file a petition for winding up, or will give 3 months time for rectification of name. Clear? And for rectification of name, what type of approval is required? Ordinary resolution is sufficient. Next one, subsection 6 is all about schedule 1. I told you in schedule 1 we are having 10 tables. 10 tables. Tables means table A, B, C, D, E for MOA, F to J for AOA. Just remember the order. First one, limited by shares, limited by guarantee without share capital, limited by guarantee with, unlimited without share capital, unlimited with share capital. Now A, B, C, D, E. These are the tables of MOA for these 5 companies. Next one, 7th subsection, it is about company limited by guarantee. Any clause in MOA which is giving a power, which is giving a right to an outsider to get share in divisible profits of company, that clause stands void. So an outsider will not get any share in divisible profits of company limited by guarantee. Clear, everyone? Next one, subsection 1, details in MOA. First one, name clause. So name of a company, in MOA, name of company shall always ends with limited in case of public company, private limited in case of private company. But for these rules are not applicable to 2 companies. For section 8 company, no need to use words limited or private limited. Government company, even though it is a private company by its articles, name shall always ends with limited. And in case of IFSC companies, they can have a suffix, IFSC. And in case of 1-person company, they will have a OPC in its name clause. Clear, everyone? Next one, situation clause. So here you will find the name of state or you will find the complete address of company. Come on, tell me. Here what you find, either name of company or complete address of company. Only name of state. Name of state in which registered office is to be situated. And what is the time limit for having registered office? 30 days of incorporation. Once company is having registered office, it is mandatory that company should file about verification of registered office with ROC. And what is the time limit? 30 days of incorporation. Understood? And the importance of registered office: communication address, jurisdiction with respect to judicial and fiscal aspects, financial matters, tax matters. Next, inspection of all statutory records. In section 7 I told you all the documents which you prepared for getting certificate of incorporation shall be preserved at registered office. So all statutory registers, books of accounts, everything company will maintain at registered office. Clear, everyone? Next one, object clause. Here you will find 2 objects. One is main objects, that is purpose of incorporation, and second one incidental objects. For attaining main objects we can carry incidental objects. Any deviation from object clause we call it as ultra virus. Ultra means beyond, virus means powers. And what are the effects of ultra virus acts? All ultra virus acts are void. Even a company cannot ratify ultra virus acts. 100% of members, even 100% of members, if they agree to ultra virus acts, that ratification valid or invalid? Invalid. Neither company nor outsiders enforce ultra virus acts, because all ultra virus acts are void ab initio. Next one, any member holding a single share can bring injunction order against company. Injunction order means stay order, stopping someone. Yes or no? Stopping someone from doing some activities. Next one, board of directors are personally liable to outsiders for ultra virus acts. So these are the effects of ultra virus acts. Next one, capital clause. In capital clause you will find three figures. One is authorized share capital divided into number of shares, nominal value of each such share. Clear? Subscription clause, here once every subscriber must agree to subscribe at least one share. Next, in case of OPC you will also find nomination clause. Understood? Now answer my question. Change in nominee. Whether change in nominee requires alteration of MOA or not. Change in nominee, whether it requires alteration of MOA or not. No. MOA will not be altered. Liability of members. Here how many companies we are having? We are talking about only limited companies. Limited by shares, limited by guarantee. In case of limited by shares, members are liable to the extent of unpaid value. Limited by guarantee, members are liable to the extent of guaranteed amount. Now tell me whether members of company will have joint and several liability or individual liability. Individual liability. That means each and every member is liable for his share of liability. He is not liable for other members. In case of limited by shares, yes, you can see, they are liable to the extent of guarantee amount and subject to deficiency amount. They contribute towards assets. In case of deficiency, they contribute towards winding up costs, and they will also contribute towards adjustment among contributories. And I told you many times, one person will be named, or one person will have four names. At the time of incorporation he is called subscriber. Upon incorporation he becomes member. Upon allotment of shares he will be called shareholder. At the time of winding up he will be called contributory. Understood? Next one. So who are liable to these three amounts? Two members. One is all present members. If present member is not in a position to pay, if present member is not in a situation to clear dues, in that case we are going to catch past member. Past member, he should be a member within. That means cessation of membership should happen within 1 year before winding up. Suppose 2 years back cessation happened. Now can we call him as a past member? No, he is not at all liable. And I told you logic, going concern we are having only 1 year assumption. Here also we are taking same assumption. So today authority ordered for winding up of company. From today onwards, just go back 1 year. Within 1 year, what are all the transfers happened? In those transfers, identify transferors. Who are transferors? The person who transfers shares. Those transferors are treated as past members. Everyone. So with this section 4 also completed. Next one, section 5. Section 5 is all about articles of association. It contains regulations for management of company, that is subsection 1. Subsection 2, it can also contain prescribed matters. That means you can adopt model articles. Model articles you will find in table F to table J. Next one, entrenchment provisions. Making simple thing into complicated thing. Converting a simple thing into difficult thing, we call it as entrenchment. Generally, for alteration of AOA, what type of approval we need? Special resolution. But in case of entrenchment provisions, we need an approval which is difficult or which is more protective compared to special resolution. Clear? So we can have entrenchment provisions either at the time of formation of company or we can have entrenchment provisions subsequent to formation by way of amendment to articles. And if you are a private limited company, for adding entrenchment provisions, you need consent of all members. If you are a public company, if you are a public company, if you are a public company, then special resolution is sufficient for adding entrenchment provisions. Clear? Everyone? Next one. Section 5 is not applicable to AOA, which was registered under previous company law. Suppose Infosys company, which was registered under Companies Act 1956, so far it didn't made any modification to AOA. So far it didn't made any alteration to AOA. In that case, that AOA is not required to comply with the provisions of section 5. Suppose Infosys company is making a modification to AOA according to Companies Act 2013, then Infosys company AOA shall comply with section 5. Clear? Everyone? Voice clear? So section 5 completed. Next one, doctrine of constructive notice. At the time of incorporation, we are filing MOA and we are filing AOA with ROC. So these two documents become public documents, and we assume that every person dealing with company have read MOA AOA and understood MOA AOA. No relaxation for negligence, no relief for negligence. And here complete protection is for company, outsider will not be protected. Understood? Next one, doctrine of indoor management. Doctrine of indoor management is an exception to doctrine of constructive notice. Here persons dealing with company are entitled to presume that internal proceedings and internal requirements have been duly met. No need of inquiry, no need of investigation. With respect to internal proceedings, you can make an assumption. Understood? But to this doctrine we had few exceptions. That means what? In the following cases, doctrine of constructive notice is applicable. I told you notice is of two types: actual notice, constructive notice. Constructive notice is nothing but deemed notice. Clear? So in the following cases, doctrine of constructive notice shall apply. What are those cases? Knowledge of irregularity, you cannot claim protection under doctrine of indoor management. Negligence, you cannot claim protection under indoor management. Forgery, you cannot claim protection under indoor management. Ultra vires acts, you can't claim protection under indoor management. So for these four cases, doctrine of constructive notice shall apply. Next one, section 6. What is section 6? Act to override MOA AOA. You can look at this chart. We are having 5 documents here: MOA, AOA, agreement executed by company, board resolution, members resolution, and other side Companies Act. Any inconsistency, any conflicts, which one will prevail? Companies Act. So Companies Act is supreme document compared to all these 5 documents. Any provision in MOA, AOA, agreement, resolution, to the extent in conflict to the provisions of the Companies Act, stands void. Okay, everyone? Next one, section 10, effects of MOA, AOA. In section 10, we studied about an assumption. What is that assumption? Upon incorporation, upon registration of MOA, AOA, these documents will act as a contractual documents between company and members, as if, come on read it, as if they had personally signed these documents. Even you become member after incorporation, you are bound by the provisions, you are bound by the contents of MOA and AOA. Clear? Everyone? Next one, section 13. What is section 13? Alteration of MOA. So in section 13 we are having total 1, 2, 3, 4, 5, 6 topics. Sixth topic you already know. Any alteration to MOA specifying that an outsider getting share in profits, that particular content becomes, that particular clause becomes void. It won't get any legal enforceability. Next one, for alteration of MOA, what type of approval we need? Special resolution. But in one case we need ordinary resolution. What is that one case? Rectification of name. Even in case of rectification of name, we are making alteration to MOA. For rectification of name, OR is sufficient. Other cases we need special resolution. And procedure for name change, procedure for change of state, and ROC filings, change of documents. Let's see. For name change, voluntary change of name, this privilege is not available to all companies. It is not allowed in case company is having following any one of the following defects. Any one. If company is having all defects, then also not allowed. If company is having only one defect, then also not allowed. What are those defects? Non-filing of financial statements, non-filing of annual returns, non-payment of debentures, deposits, interest thereon. Once you rectify these defects, yes, you can proceed with change of name. Next, what is the procedure for change of name? First, file RUN for reserving unique name. RUN, reserving unique name. So here, the name shall be reserved for a period of 60 days. And this particular form is not required in case of change of name because of change in constitution of company, that is public to private, private to public. For conversion of public to private, private to public, RUN is not required. Next one, call for general meeting. In general meeting, obtain special resolution. Then amend MOA, amend AOA. File all these documents with ROC. And ROC shall issue fresh certificate of incorporation. Along with new name, add your old name for a period up to 2 years. Understood? And every filing should be, filing of special resolution shall be done within 30 days from the date of special resolution. So here, filing, the time limit is within 30 days. Clear? Everyone, this is all about voluntary change of name. Next one, rectification of name. Sir, when rectification of name comes into picture, in two cases. One is name of a company is identical with or resemble to name of existing company, or name is identical with or resemble to existing registered trademark. In case if it is similar to existing company name, central government by default, or central government is having a power to issue an order to company to change its name. Within how many months? 3 months from the date of order. Within 3 months from the date of order, if they change it, no problem. Or else, central government allots new name to that company. Now within 3 months, what they should do? First, they should conduct general meeting. In general meeting, they should pass ordinary resolution, alter MOA, AOA, and filing with ROC within 15 days of alteration. And ROC shall issue fresh certificate of incorporation. In case name of company is identical with or resemble to name of existing registered trademark, in that case, registered trademark owner has to file an application with the central government, and that application shall be filed within how many years of incorporation? 3 years of incorporation. Suppose the registered trademark owner wants to file an application with CG after 5 years of incorporation. Is that application valid or invalid? Invalid. That application shall be filed within 3 years of incorporation. Now central government, if it is satisfied, then it will send an order to company to rectify its name. So in how many months company has to change its name? Within 3 months. And what is the procedure? Same procedure. Understood? Next one, change of registered office. Change of registered office. So change of registered office is possible in following 4 ways. One is within same city. Other one, change in city but no change in state, no change in ROC. Third one, change in ROC, and last one, change in state. Very simple equations. Board resolution plus ROC filing for case 1. Board plus members plus ROC in case 2. Case 3, just regional director approval is getting added. And in case 4, creditors consent is required. Here creditors 2 types, trade creditors, debenture holders. Understood? So non-trade creditors. So once we get approval from creditors, yes, regional director will also give approval. And for that, you need to file an application with regional director. Along with that application, you need to attach following documents. One is altered copy of MOA, general meeting minutes, board resolution, special resolution copies, a list of creditors, acknowledgement of service of copy of application to ROC, Chief Secretary, and copy of advertisement. Advertisement shall be given, 30 days before filing application with regional director. 30 days before filing application with regional director, company has to make an advertisement in 2 newspapers, and that advertisement copy also they should attach. Finally, once we get the regional director approval, then proceed with ROC filings. So time limits you can see here. So within how many days RD should give approval, within how many days RD should give order? In case of change in ROC, no change in state, 30 days. In case of change in state, 60 days. Understood? Next one, filing of regional director order. For case 3, within 60 days of regional director order, company has to file it with ROC. Whereas change in state, 30 days of order, company should file regional director order with ROC. And ROC shall register the same and issue certificate within 30 days of filing. And finally, file INC 22 within 30 days of shifting of registered office. Clear? Everyone? Next one, change of objects. For alteration of objects, what is the procedure we should follow? First, call for general meeting. In general meeting, obtain special resolution. And next one, give an exit offer to dissenting shareholders. Who should give exit offer to dissenting shareholders? Either promoters or shareholders having control. Next one, proceed with alteration of MOA and proceed with filings with ROC. ROC shall register the same and issue certificate within 30 days of filing of special resolution. Clear? Everyone? Next one, with that section 13 completed. Defaults, 1000 rupees per day. 1000 rupees per day, maximum 1 lakh rupees is the fine amount. That fine amount is common. 1000 per day, maximum 1 lakh. Next one, alteration of AOA. So what type of approval we need for alteration of AOA? Special resolution. And this alteration also includes conversion, that is section 18. Private to public, public to private. Come on, tell me, in which case we need to take central government approval, ma? Private to public or public to private? Why? In public company, public funds are involved. In public company, public funds are involved. And the number of members shall be reduced to 200. Before getting converted into private company, number of members should be reduced to 200. So here you will find central government approval. And remaining procedure common, special resolution. For private to public, delete section 2 clause 68. For public to private, add section 2 clause 68. First of all, tell me what is section 2 clause 68? Definition of private company. Here you will find restrictions on transfer of shares, limit on number of members to 200, prohibition on invitation to public to subscribe securities of a body corporate. Clear? If you delete, private company gets converted into public company. If you add, public company gets converted into private company. Any alteration, file it with ROC within 15 days. And altered articles of association, upon registration, it will have same effect as if it is an original articles. Okay, na? Everyone? Yes, for getting conversion of public into private. So company has to file an application with regional director within 60 days of special resolution. And these are the attachments. These are the attachments. What are those attachments, ma? So just look at the point, ma. Company for getting itself converted into public company, public company wants to convert itself into private company. In that case, it has to file an application with regional director. Here I told CG approval is required, but here I am telling about regional director. That means what? Power already delegated to regional director. Clear? So along with application, attach following documents: altered MOA, AOA, general meeting minutes, copy of board resolution, copy of special resolution, and declaration of compliance. Clear? And this application shall be filed within 60 days of passing special resolution. Next one, there will be no effect on the debts, liabilities incurred before conversion. So before conversion, what are the debts, what are the liabilities of company? Same debts, same liabilities shall continue without any effect. Next one, section 15, that is alteration of MOA, AOA to be noted in every copy. In case of default, company and officer in default will get a punishment. Punishment is how much? 1000 per copy issued without such alteration. Clear? Next one, section 17. Any member can request company in writing, and upon payment of fees, it is the duty of company to share or to send copy of documents within 7 days. So conditions, two conditions. One is written request of member, and second one, payment of sufficient fees. So duty of company to send copy of documents within 7 days of written request. And in case of default, company as well as officer in default will get a punishment of 1000 rupees per day. Maximum 1 lakh rupees. For the number of days they are making delay, for each day they are liable to pay penalty of 1000 rupees, maximum how much? 1 lakh. So 10 days delay, 10 days delay. In case of 10 days delay, 10 into 1000, that means 10,000. In case of 50 days delay, 50,000. In case of 120 days delay, it is 1 lakh only. Why? Maximum punishment is restricted to 1 lakh. Next one, section 12. What is section 12? Registered office of company. In registered office of company, we are having total 5 topics. First one, every company upon incorporation shall have registered office within 30 days. For IFSC companies, it is 60 days. And immediately, after having registered office, after opening registered office, may file a form with ROC. What is that form? INC 22, verification of registered office. Next one, labeling of company. So at the entrance of each and every branch office, at the entrance of registered office, company shall have a name board. And in that board, you should find this, you should have these components. What are those components? Name, SIN, registered office address, telephone number, fax if available, email ID, website if available. And this content, it should be there on name board as well as on all official publications of company. Understood? And coming to name board, yes, it should have 2 languages. Name shall be available in 2 languages. One is English language, other one is local language, regional language. Next one, alteration of registered office. You all know alteration. In how many ways we can change registered office? In 4 ways. Within city, change in city, no change in ROC. Change in ROC, no change in state. Last one, change in state. Clear? So that already covered ma. And next one, finally default. In case of default of section 12 provisions, company as well as officer in default will get a punishment of how much? 1000 per day, maximum 1 lakh rupees. Here 30 days concept is there, right? Suppose if you are not complying within 30 days, then 1000 rupees per day during such delay continues, maximum 1 lakh rupee. If company is not carrying business operations, ROC will make a inquiry, and if ROC came to know that company is not at all carrying business operations, then ROC is having power to remove name from register. Clear? Everyone. Next one, commencement of business. Section 10A. A company which was incorporated with the share capital and which was incorporated after 2nd November 2018 shall not commence business, shall not exercise borrowing powers unless these 2 conditions are satisfied. What are those 2 conditions? First one, filing a declaration with ROC regarding paid up value. And the other one is filing a verification of registered office form with ROC. For INC 28, time period is 180 days of incorporation. For INC 22, 30 days of incorporation is the time period. After complying these 2 conditions, yes, company can exercise borrowing powers, company can commence business operations. In case of default, company will get a punishment of 50,000 rupees penalty. Officer in default, it is 1000 per day during such delay continues, maximum 1 lakh rupees. And in case of non-filing, registrar will conduct a reasonable inquiry. After reasonable inquiry, if ROC came to know that company is not carrying business operations, then ROC had a power to remove name from register. Next one, section 19. What is section 19? Subsidiary not to hold shares in holding company. So prohibition, this prohibition will also extends to subsidiary nominees. That means what? Not only subsidiary, but nominees to subsidiary not to hold shares in holding company. So this rule is applicable to 2 persons. One is subsidiary company and second one is subsidiary company nominees. Understood? Any allotment or any transfer of shares in a holding company to its subsidiary company shall be void. But to this general rule, we had 3 exceptions. That means in following cases, subsidiary company can hold shares of holding company. What are those 3 exceptions? As a legal representative, as a trustee, as a shareholder. Understood? As a shareholder before it became subsidiary. Understood? But in these 3 cases, 2 cases voting is permitted and last case voting is not permitted. So in first 2 cases, legal owner is subsidiary company, whereas beneficial owner is outsider, other party. Whereas in case 3, legal owner subsidiary company, beneficial owner is also subsidiary company. So here voting is prohibited, but for first two cases voting rights are allowed. Next one, section 20, service of documents. So who can serve documents to whom? Any person, member, ROC, any department, income tax department, registrar of companies can serve document to either company or officer. In case of service of documents to company or officer, that letter or notice shall be addressed to company address or officer address. And coming to mode of service of notice, yes, we can use a registered post service, speed post service, courier, or leaving it address directly or through electronic mode. And this section also covers service of documents by company to ROC as well as members. That means to and fro, simply to and fro. Any person to company, company to any person. Member may request for a particular mode. In that case, member should deposit a sufficient amount. Member should deposit sufficient amount with company. To meet these instructions, to meet these directions, member has to deposit or member has to make payment of prescribed fees. In case of Nidhi companies, which companies? Nidhi companies, service of documents, service of documents to the members only if they are holding face value of shares rupees 1000 or 1% of paid up share capital, whichever is less. For other members, service of documents is satisfied when you advertise it in local newspaper or when you attach it in notice board. So to the members holding face value of 1000 rupees shares or 1% of paid up share capital, whichever is less, serve documents personally. For remaining, advertisement is sufficient or display of notice in notice board is sufficient. Clear? Next one, section 21, authentication of documents, proceedings and contracts. Who can authenticate company documents? Either KMP or authorized officer or authorized employee. Who authorized officer or employee? Board. How they give authority, how they give authorization? Through letter of authority. In case company is having common seal, then two directors and common seal, two directors shall sign letter of authority and common seal shall be affixed on the letter of authority. In this way, officer or employee gets authority. Suppose company is not having any common seal. In that case, two directors signing letter of authority. Suppose company is having secretary, then one director and one company secretary signing letter of authority. That employee or officer gets authority. Understood? And section 22 is all about execution of bills of exchange. Who can execute bills of exchange on behalf of company? Authorized person. How authority will be given to that person? Through letter of authority. Who should sign this letter of authority? If company is having secretary, one director and one secretary. If company is not having secretary, then two directors. If common seal is there, then affix common seal also. Understood? So this is section 22. With this, revision of incorporation of company and the matters incidental thereto completed. So now I'll revise chapter 3, prospectus and allotment of securities, section 23 to 42. Section 23 is about public offer and private placement. In this section, we are having total 4 subsections. Subsection 1, public company can offer its securities to public at a large through prospectus, or it can offer securities to identified persons through private placement offer cum application letter, or it can offer securities to its existing members either under rights issue or bonus shares. Now coming to private company, it can offer its securities only to identified persons through private placement offer cum application letter, or it can offer its securities to existing members. If it is for money, we call it as rights. If it is at free of cost, it is bonus issue. Subsection 3, prescribed class of public companies. Authority is giving power to prescribed class of public companies to list their equity shares, to list their securities on permitted stock exchanges in permissible foreign jurisdiction. Is it clear? Now what is a listed company? A company whose securities, any of its securities listed on any one of recognized stock exchange, it is a listed company. But to this general rule, we had few exceptions. Suppose if you take public company, equity shares unlisted, but non-convertible redeemable preference shares, non-convertible debentures which were issued under private placement, even though they are listed on recognized stock exchanges, the company remains unlisted company. And even if you take private company which offered non-convertible debentures under private placement basis and which are listed on recognized stock exchanges, still private company is treated as unlisted company. Clear? Next one, subsection 4, this is all about powers of central government in granting exemption to prescribed class of companies. So prescribed class of public companies, they are exempted from complying chapter 3 prospectus and allotment of securities, chapter 4 share capital and debentures, 89, 90, 127. 89, 90 I'll discuss with you under management and administration. In management and administration topic I will discuss with you 89, 90. Declaration of dividends, I'll discuss section 127. So this is all about section 23. Next to section 24. But before that, we are having definition. We are having definition of securities. And we are also having definition of public offer. Public offer includes IPO, initial public offer, further public offer, offer for sale of securities. After incorporation, first time it is making public offer, IPO. Any public offer subsequent to IPO, we call it as FPO. And selling shareholders, few shareholders or promoters can authorize company to sell their holdings, in the company. Understood? So what is the difference between fresh issue and offer for sale of securities? Under fresh issue, company capital base will increase, whereas under offer for sale of securities, company will take shares from existing members and it will dispose them to the public. So whatever money company is getting, company will reimburse that money, company will refund that money to selling shareholders. Securities. Securities includes all shares, scrip, stock, bonds, debentures, debenture stock and all other marketable securities. Securities include derivatives. Securities includes collective investment scheme units of collective investment scheme. Security includes security receipt issued under SURFACE Act. And then securities include mutual fund scheme units. That means units of mutual fund scheme. Next one, security includes certificate issued by special purpose distinct entity. And securities include government securities, rights or interest in securities, rights renunciation. In case of right shares, we are having a option of renouncement. That is also a security. And other notified securities. And it is very important to remember an item which is not security. Unit linked insurance policy is not a security. Clear? Now, if company is offering any of its securities to public at a large, then company is required to issue a document called prospectus. So here, securities is not restricted to shares. Security is extended to all these items. Next one, section 24, powers of CG and SEBI. CG 2 letters, 2, 4 letters, SEBI 4, 24. Section 24. So company here classified into two categories, listed companies and companies in the process of listing. And all other companies. In the process of listing means they filed an application for listing. That application is a two process. If application is approved, then we call it as listed company. In these two companies, I categorize matters into two parts. One is issue of securities, transfer of securities, non-payment of dividend, and all other matters. Now these three matters in these two companies are taken care by SEBI. So SEBI is going to issue regulations for governing these activities, for regulating these activities. And all other matters and all matters in other companies are regulated by central government through Companies Act 2013 and rules made thereunder. Best example, for shifting of registered office, whether it is listed company or unlisted company, it should comply the provisions of Companies Act. And listed companies, for issue of securities, they need to comply SEBI norms. Clear? So that is all about section 24. Next, section 25, deemed prospectus. So what is section 25? But before that, what is a prospectus? So prospectus, the definition is two parts, means, includes. Prospectus means any document described or issued as a prospectus, then it becomes prospectus. And prospectus also includes shelf prospectus, red herring prospectus, deemed prospectus. So deemed prospectus means here any circular, advertisement, notice and whatever name you keep, any other document inviting offers from public for subscription or purchase of any securities of a body corporate. We use word subscription for fresh issue and we use word purchase for offer for sale of securities. So any document fulfilling these four conditions, it is deemed to be prospectus and it should comply provisions of section 26 or else section 34 criminal liability, section 35 civil liability will apply. Now 25, document containing offer of securities for sale deemed to be, to be deemed prospectus. In this section, it is very important to understand when offer becomes public offer. In two cases, offer becomes public offer. First of all, here what happens, company either it allots or agrees to allot securities in the name of a middleman. Here I call middleman as issue house. Why it is making allotment? With an intention to offer those securities to public for sale. Now, if this offer is made within 6 months of this allotment, or when the offer is made, whole consideration has not been received. Under these two situations, this offer is deemed to be public offer. Accordingly, section 26 will apply. If section 26 is not complete, that means, if the prospectus is not having complete information or correct information, then 34 criminal liability, 35 civil liability shall apply. Is it clear? So this offer is said to be public offer, and this document is said to be prospectus when an offer for sale to public by issue house is made within 6 months of allotment by company, or when whole consideration has not been received. Here it is very important to understand whole consideration. Whole consideration means even 1 rupee pending, we consider that offer as deemed public offer. It is deemed to be public offer. Next one, what are the contents of deemed prospectus? In this deemed prospectus, section 26 contents, that means, this prospectus shall contain matters and reports on financial information as may be specified by SEBI in consultation with central government. So yes, this prospectus should contain all those contents. In addition to these contents, this prospectus should contain net consideration received by company and receivable by company from issue house. And what is the time and place of inspection of contract, which is between issue house and company. So these two things we need to provide in deemed prospectus. Now tell me, who will sign deemed prospectus? Issue house authorized persons. If the status of issue house is a firm, then majority of partners shall sign deemed prospectus. If the status of issue house is a company, then 2 directors shall sign prospectus, and these people are deemed to be directors of the company. Okay, so accordingly section 26, 34, 35 applicable. Next one, section 26. So deemed prospectus completed. Next one, section 26. Matters to be stated in prospectus. First point, it is very clear. Every prospectus prepared by company shall be signed and dated, and it shall contain information and reports on financial information as may be specified by SEBI in consultation with CG. In addition to this information, we need to provide a declaration regarding compliance. Nothing in this prospectus is contrary to Companies Act. Being a company, I should comply all provisions of Companies Act, and I'm issuing securities, so I should comply Securities Contract Regulation Act. I'm offering securities to public at a loss, so I need to comply SEBI 1992, SEBI Act 1992 provisions. Not only these acts, but also rules and regulations made thereunder. Is it clear? So this is first subsection. Next one, prospectus is not applicable in the below mentioned 2 cases. When an offer is made to the existing members or existing debenture holders, prospectus is not required. When securities offered belongs to a class of securities, which is uniform in all respects, with the securities which were previously issued and dealt on recognized stock exchange. Suppose, sir, offered securities belongs to one class, that class was subscribed by promoters. They were not issued to public, they are not dealt on recognized stock exchange. Now, when you are offering such kind of securities, prospectus is must and should. Getting my point, students? So prospectus is not required when securities belongs to existing class which were already issued to public and which were already dealt on recognized stock exchange. Any one condition not satisfied, then prospectus is compulsory. When these 2 conditions are satisfied, prospectus is not necessary. Clear? So prospectus is not necessary in 2 cases. What are those cases? Offer made to existing members, offer made with respect to securities which are uniform in all respects with the securities which were previously issued and dealt on recognized stock exchange. Other 2 cases are there in material, when offer is made by private company or when offer is made to identified persons. Yes, in those cases also prospectus is not required. Next one, prospectus is applicable not only to IPO but also FPO. For both IPO, FPO, we need to prepare prospectus. Next one, every prospectus before publication. So before issuing prospectus to public, every prospectus shall be filed with ROC. And what is the time limit? Before issuing to public. Suppose you decided at 12 o'clock noon, you decided to issue prospectus to public. Before that, you need to file a copy of prospectus with ROC. And can I include expert statement in prospectus? Yes, provided following three conditions to be satisfied. One is that person, that expert is not engaged or interested in promotion of the company, formation of the company, management of the company. And he must give written consent to include his statement in prospectus. And he should not withdraw such consent till a copy has been filed with ROC. And disclosure of the facts should be made on the copy of prospectus. So we included expert statement, we complete with the respective provisions. Next one, disclosures. Copies filed with ROC. Yes, on each and every copy of prospectus, there should be a disclosure regarding a copy of prospectus has been filed with ROC. And list of documents attached with copy. Suppose underwriting agreement is there. So we filed underwriting agreement along with prospectus. Now mention the list of documents. Yes, we filed underwriting agreement along with prospectus. Like that, just disclose list of documents attached with copy. Next one, what is the validity period of prospectus? Every prospectus is having a limited validity period. That validity period is 90 days of filing with ROC. That means within 90 days of filing with ROC, you should issue prospectus to public. Suppose you forgot 90 days completed. Now can I issue same prospectus to public at a large? No, you need to prepare fresh prospectus. This time again you file it with ROC. Now you can issue it to public. In case of contravention, company as well as party who is authorizing issue of prospectus, he may be present director or he may be proposed director or promoter, CEO, CFO, any person who is authorizing that issue of prospectus will get punishment. Fine how much? 50,000. Minimum 50,000, maximum 3 lakhs. This is all about section 26. Next, 27. Variation in terms of contract or objects in the prospectus. Variation in terms of contract or objects in the prospectus. Possible or not possible? Possible. We can change terms and conditions. We can change terms of contract or we can change objects in prospectus only with members approval, that is special resolution. For getting special resolution, first you need to give notice with prescribed details. For what purpose you raised money, how much money you raised, how much money you utilized for present objects, and what is your proposed object, how much amount we need, risk factors associated with proposed object, time schedule for completing proposed object. Everything you provide in notice. And this notice shall be published in 2 newspapers. One is vernacular newspaper and the other one is English newspaper having wide circulation. In addition to that, publish notice on company's website. Now after getting special resolution, identify dissenting shareholders and provide and give this exit offer. Who will give exit offer to dissenting shareholders? Either promoters or shareholders having controlling power. And the money which you raised through issue of prospectus, that money you cannot use for one purpose. That purpose is carrying speculation transactions. That means buying, trading, dealing in equity shares. In equity shares of other listed company. Is it clear? Everyone? Next one, section 28. Offer of sale of shares by certain members of company. Only 3 points, small section. Here members in consultation with board of directors authorize company to sell their shareholdings, to sell their shares to public at a large. And here members who authorize company will also authorize company to get reimbursement of all expenses connection with section 28. So all the expenses incurred by company for making offer of sale of securities, company is going to get reimbursement from members. That means, company, whatever amount company collected, suppose 600 crores, from that expenses will be deducted and balance amount, company is going to give it to members who authorize company to sell their shares. And this offer of sale is deemed to be public offer. Accordingly, section 26 shall apply. Any information in the prospectus is incorrect or incomplete, then section 34 criminal liability, 35 civil liability shall apply. Understood everyone? So that is all about section 28. Next, section 29, public offer of securities to be dealt in demat form. So demat form is compulsory for companies making public offer and prescribed unlisted companies, and for all other companies issue of securities in demat form is optional. Section 30, come on, tell me whether advertisement of prospectus mandatory or optional. Optional. But if you prefer advertisement of prospectus, the advertisement shall contain following contents. One is contents of MOA. What are those contents? Objects of the company, liability, signatories to MOA, and what is the authorized share capital, and what are the shares, how many shares subscribed by the signatories. In addition to this information, provide capital structure of the company. So that is all about section 30. Next one, section 31, shelf prospectus. So who can avail the offer of shelf prospectus? Sorry, who can avail the benefit of shelf prospectus? SEBI prescribed companies. This benefit is not available to all companies. Only SEBI prescribed companies can issue shelf prospectus. But if before issuing shelf prospectus, one copy they need to file with ROC. And this shelf prospectus will have a validity of 1 year from the date of prospectus, date of opening of first offer of securities under shelf prospectus, date of opening of the first offer of securities under shelf prospectus. So validity period commence date is opening date, date of first public offer under shelf prospectus. From that date onwards, 1 year validity period is there. So during this 1 year, company can make second or subsequent public offers even without issuing prospectus. And for subsequent public offers under shelf prospectus, it is the duty of company to prepare a document called information memorandum. And that information memorandum shall contain information about new charges created during that period, changes in financial position, and prescribed other matters. So prepare information memorandum, file it with ROC at least 1 month before, 1 month prior to issue of second or subsequent offers. So filing of information memorandum with ROC 1 month prior to issue of second or subsequent offers. Actually, this condition is not there in Act. This condition is there in rules. Even we identified the same in material also. This is a condition from rules. Next one, company has to give intimation. Company has to intimate persons who deposited money in advance. Persons who file an application in advance, yes, they are entitled to get one intimation, and company is liable, company is responsible to give one withdrawal option. So if these persons willing to withdraw, if they opt for a withdrawal option, then company has to refund all those monies within 15 days. Or else company can proceed with allotment of securities in the name of these persons. Clear? Now finally, shelf prospectus together with information memorandum is deemed to be prospectus. Clear? Clear. When you read the definition, prospectus includes shelf prospectus, red herring prospectus, deemed prospectus. That means what? Chapter number 3, prospectus and allotment of securities, generally applicable to prospectus. Now these rules are also applicable to shelf prospectus, red herring prospectus, deemed prospectus. That is the real logic of definition. Next one, shelf prospectus completed. Next one, 32, red herring prospectus. Prospectus which does not include complete particulars. Example, quantum of securities, issue price of securities. Now here at the timing, timing of issue, when we issue red herring prospectus, before public offer or after public offer? Before public offer. That means, before issue of final prospectus, we issue red herring prospectus. And this is before public offer. So timing of issue, we issue red herring prospectus prior to final prospectus. And it should be filed with ROC at least 3 days before opening of the offer. It's not issue of prospectus to public. It's 3 days before opening offer period. And coming to the obligations, red herring prospectus. For red herring prospectus also we need to apply section 26, 34 and 35. But what are the differences between shelf main and abridged prospectus, main prospectus, red herring prospectus and main prospectus? If you observe, red herring prospectus, for main prospectus, general rule, it should contain complete information, whereas red herring prospectus, incomplete information. Main prospectus validity period 90 days, shelf prospectus validity period 1 year. Understood? So these are the exceptions. Next one, variations shall be highlighted. We prepare red herring prospectus at one point of time, that is before public offer, and we prepare final prospectus after public offer. During this period, any changes happen in the company, any changes in the content of red herring prospectus shall be highlighted in final prospectus. And final prospectus, file it with ROC and SEBI upon closing of offer. And here, for discovery of price, what technique we use? Book building offer. We use book building technique for discovery of price. Clear? So that is all about section 32, red herring prospectus. 33, abridged prospectus. Generally, prospectus should contain complete information, but abridged prospectus contains only material information. Material information. Here, application form accompanied by abridged prospectus. Every security application form issued by company shall be attached to abridged prospectus. Understood? But this abridged prospectus is not applicable in case of an advertisement inviting underwriters in case of securities not offered to public. Next one, yes, any person after going through abridged prospectus can request for full prospectus, and it is the duty of company to submit full prospectus to the requested person. In case of any default, company liable to pay how much fine? 50,000 rupees. Here punishment is only with respect to company. And for each default, what is the punishment amount? 50,000. Clear? So first of all, abridged prospectus means it's a memorandum containing salient features of a prospectus as may be specified by SEBI. Information memorandum different, this memorandum different. Information memorandum, we use it under shelf prospectus. Memorandum containing salient features, it is abridged prospectus. Can I proceed? Next one, misstatement. First of all, misstatement means what? Any untrue statement or any misleading statement, it is misstatement. Next one, omission to include any matter which is likely to mislead. That means, providing incorrect information, it is misstatement. Providing incomplete information, it is also misstatement. Now, what are the consequences of misstatement in prospectus? First, section 34, criminal liability. According to this section, every person who authorizes issue of such prospectus will get punishment under section 447. If he want to take any defense, then he need to prove that misstatement is immaterial, or he should prove that, sir, all the statements included in the prospectus or all the statements which are omitted from prospectus, he had a reasonable ground to believe. He had a reasonable ground to believe all those statements are true. All those omissions are required. Understood? So up to time of issue of prospectus, he had reasonable grounds to believe that misstatement is not, that statement is not misstatement, that statement is true statement. Up to when? Up to the time of issue of prospectus. And example for misstatements, false statements, concealment of truth, ambiguous statements. Ambiguous statements means not certain. Not certain. Understood? Like payment of dividends. Payment of dividends, you are just hiding the truth. You are paying dividends out of capital realized profits, realized capital profits. Now, realized capital profits, you are not using that sentence. You are not using that words. Now, what people think, you are paying dividends out of revenue profits. So, this is one kind of misstatement. Next one, civil liability. Criminal liability, civil liability, both are independent. Don't think that 34 is applicable. If 34 is applicable, 35 will not apply. No, no, no. All these are independent sections. Even 34 is applicable, 35 will also apply. But 35 is applicable only when certain conditions are satisfied. First of all, prospectus shall contain misstatement. And subscriber on the faith of prospectus made subscription and finally he incurred loss or damage. Suppose if you observe Paytm, company Paytm, it made an offer at around, I think, if I'm not wrong, the offer price is 2000. Issue price is how much? 2000. Prospectus contain complete information, correct information. There is no misstatement in prospectus. But due to fall in economy or due to no growth in company prospects, what happened? Share price fall into 600 rupees. Paytm share price fall into 600. Now, if you observe carefully, on each share there is a loss of 1400. Now, can a subscriber to prospectus, can he claim loss of 1400 rupees from company? No. Why? This is because market conditions. Suddenly Iran-Iraq war, Iran country, Israel countries, they announced that they declared war. As a result, what happens? Stock markets will fall. Now, for this also, can we claim losses? Can we claim compensation from company? No. For claiming compensation from company, first of all, there should be misstatement. One condition missing, then section 35 will not apply. All conditions should be satisfied. Even if one condition is missing, no misstatements are remaining, entire conditions satisfied. Or misstatement is there, but there is no loss or damage to subscribers, sir. Then also section 35 will not come. Section 35 comes only on satisfaction of these 4 conditions. And what is the punishment? 6 persons has to compensate suffered investors. Who are those 6 persons? Company, present director, proposed director, expert, promoter, person authorizing issue shall compensate all the losses incurred by subscriber to the prospectus without any limit on liability. Next one, defense. If he want to take defense, he can take following defenses: either withdrawal of consent from prospectus before filing a copy with ROC, or giving a public notice that without my intention, without my consent, my name was wrongly included in the prospectus, or I believed expert, on the faith of expert report I gave my consent to the prospectus. And in practical questions we had 2 questions, where directors relied promoter statements and directors gave consent to prospectus. Now can they claim exemption from section 35? No, because faith of promoter is not covered under the following defenses. Next one, remedies for misrepresentation in prospectus, either misrepresentation or misstatement. So what are the remedies available? Against company, rescission, cancellation of contract, or claim damages. Continue the contract by claiming damages. Whatever losses you suffered, get compensation. Next, against company and others, civil liability, section 35. Next one, against persons authorized to issue. Yes, these people will get criminal liability under section 34, and we can also claim damages for fraud. Understood? And next one, section 36, punishment for fraudulently inducing persons to invest money. Here I told you 2 examples. One is Satyam Computers and second one is Harshad Mehta. Yes or no? So what these people are doing, they're making some statements, some fake promises, some forecast, predictions which are false, fraudulent, deceptive, misleading. Why they are making these statements? To induce another person to enter into following any of these agreements, namely acquiring, disposing, subscribing, underwriting securities, or secure profit from yield of securities or fluctuations in securities value. Spreading some fake news. And sudden fall of share price, at sudden fall of share price, we are going to purchase huge quantity, and when price becomes normal, when price comes to normal range, we are selling those securities. So like that, any person spread any fake statements. Next one, any person making statements in order to obtain credit facilities from the banks or financial institution, then those persons will get punishment under section 447. So this is all about section 36. Action by affected parties. Here group of investors, they can file a single complaint against company and persons authorizing issue of such prospectus. So separate complaints are not required, one complaint is sufficient. So suit may be filed by any person, by one person on behalf of entire group. That means any person on behalf of group or entire group of persons or any association of persons, these people can file suit against company, that is class action suit. 38. What is 38? Punishment for personation for acquisition of securities. So here what a person is doing, so what is the main objective of this section? What is the main purpose of this section? Preventing allotment of shares in fictitious name, preventing allotment of securities in fictitious name. So what is happening in this situation? Person is filing an application for securities in a fictitious name, or person is filing application in his own name but in different names, different combination of name using surname. Understood? Next one, induces company to allot or register any transfer of securities in the name of fictitious person. In that case, that person will get punishment under section 447. And you need to disclose this content in prospectus, disclosure in prospectus. In case of conviction, yes, from the convicted party we can seize all the securities and we can also take all the gains he earned from these activities, and all those gains and securities shall be transferred to IEPF. If company is making any delay in transferring amounts to IEPF, that means if company is making a default, then after rectification it is prohibited for a period of 5 financial years from issuing equity shares with differential rights, section 43. Remember? Okay. And what is the punishments for fraud? Section 447. So here 2 categories, public interest affected, like Satyam Computers, public interest not affected. In case of public interest affected cases, fine minimum fraud amount, maximum 3 times of fraud amount. And here word and should be used. It's not fine or imprisonment, it's fine and imprisonment. Fine and imprisonment. Imprisonment minimum 3 years, maximum 10 years. Sir, fraud involves no public interest. Fraud involves no public interest. In that case, we need to compare amount of fraud with one one amount. What is that amount? 10 lakhs or 1% of turnover, whichever is lower. So with this number, we are going to compare amount involved in the fraud. If amount involved in the fraud is equal to or greater than, two things are considered, whether it is equal to or whether it is greater than 10 lakhs, then fine minimum fraud amount, that means amount involved in the fraud, maximum 3 times of the fraud, and imprisonment minimum 6 months, maximum 10 years. Okay now. And I told you one example, section 8 companies, we are using section 8 companies for converting black money into white money. Here imagine public interest is not affected, public is not losing money. In that case, punishment will be under this. Understood? Next one, other cases, that means fraud amount is less than 10 lakhs or less than 1% of turnover, whichever is lower, then fine is up to 50 lakhs, imprisonment is up to 5 years or both. So this is all about section 447. Next, section 39. What is section 39? So you can observe carefully. In terms of Indian contract, we are having 3 terms: invitation to offer, offer, acceptance. Here invitation to offer means prospectus, offer means application by applicants, acceptance means allotment by company. Now tell me, when contract comes into picture, accepting invitation to offer contract comes or accepting offer contract comes? Accepting offer we get agreement, we get contract. Yes or no? So simply if you accept prospectus, contract will not form. So company, it is in the hands of company whether to accept it or not. Now tell me, allotment, who will take care of allotment? Company. So allotment means act of appropriation out of unappropriated capital of the company. Previously unappropriated capital. Okay. So what are the requirements, ma? What are the requirements for allotment of securities? Minimum subscription and minimum application money. So how much is the minimum subscription? How much is the minimum subscription? Amount stated in prospectus as minimum subscription. It should not be lower than 90% of public offer. Understood? And this amount shall be received by company either by check or through any other instrument, but not through cash. Next one, minimum application money. How much is the minimum application money? 5% of nominal value of security or such other percentage as may be specified by SEBI. Now tell me, I should satisfy any one condition, I should satisfy both the conditions. I should satisfy both the conditions. And what is the time limit for satisfaction of these conditions? 30 days. Suppose within 30 days these conditions are not satisfied. Within 30 days from date of issue of prospectus, if conditions are not satisfied, then refund all application monies within 15 days from the date of closure of issue. That means closure of offer period. Suppose if conditions are satisfied, then proceed with allotment of securities. In case you proceeded with allotment, then company has to file return of allotment with ROC within 30 days of allotment. In case of no allotment, what is the timeline for refund, ma? 15 days from closure of issue. It's not closure of, it's not issue of prospectus. Issue of prospectus is for 30 days. Closure of issue, the time period is 15 days. In case of delay, directors, officers in default are liable to pay interest. How much? 15% per annum. Only for delay period. So for this 15 days, interest liability comes or not comes? Not come. For this 15 days, there will be no interest liability. Only for delay period, they are liable to pay interest. And what is the rate of percentage? Now, what is the rate of interest? 15%. Who will pay? Company or directors? Directors. In case of default in refund or in case of delay in filing PAS3 with ROC, the punishment will be company and officer in default will get punishment. What is the punishment? 1000 per day during such default period continues, maximum 1 lakh rupees. This is all about section 39. Next, section 40. Securities to be dealt with in recognized stock exchanges. So before making public offer, every company has to file an application with at least one recognized stock exchange, and it should obtain permission from majority of stock exchanges or all the stock exchanges, all the stock exchange with which it filed an application for listing. And you need to disclose the names of stock exchange in the prospectus. This is one part. Next one, you can use application money only for 2 purposes. One is either adjust against allotment or refund of monies in case of unable to allot. any waiver of the conditions in the prospectus. Prospectus containing a clause stating that waiver of conditions, waiver of any compliance condition, that clause becomes void. And in case of defaults, company minimum 5 lakhs, maximum 50 lakhs. Officer in default, minimum 50,000, maximum, this is the punishment. And in section 40, we are having one more concept, that is payment of underwriting commission. What are the conditions to be satisfied for payment of underwriting commission? AOA authorization, sources, either you can use company profits, revenue profits, or issue proceeds, sometimes both. And there is no restriction on payment of commission in cash or kind. You can pay commission either in cash mode or in kind mode also. And what is the rate of commission, ma? For shares, maximum 5% or rate mentioned in AOA, whichever is lower. For debentures, it is 2.5% or rate mentioned in AOA, whichever is lower. And this percent is applied not on face value but on issue price. No commission on securities not offered to the public. Okay, if securities are offered to the promoters, or if securities are offered to identified persons under private placement, underwriting commission allowed or not allowed? Not allowed. Disclosures and filings with ROC. Yes. 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 Even in utilization of securities premium, we are having that point. Expenses connected with issue of securities, any discount or commission, we can utilize securities premium. Next one, global depository receipts. Who will issue depository receipts? Depository. Where he is issuing? Outside. So we call him as overseas depository. And the receipts, if they are offered in America, American depository receipts. Understood? Other than America, global depository receipts. Overseas depository will offer these receipts based on shares allotted by company. These shares are deposited with domestic custodian bank, and overseas depository will have a depository agreement with company and custodian agreement with the domestic custodian bank. And for issuing global depository receipts, board resolution, board resolution is for calling general meeting, and in that general meeting you need to take a approval of members, special resolution. And coming to voting right, until GDRs are converted into securities, GDRs, they are just receipts. And the value of GDRs depends on underlying asset, that is shares. These receipts can be converted into shares. Until such conversion, voting rights shall be exercised by overseas depository on behalf of overseas investors. After conversion, holders of securities can exercise voting rights in general meeting of company. Clear? Next one, private placement, last section. Private placement. Any offer or invitation to subscribe securities made to select group of persons through a document called private placement offer cum application letter. And what are the conditions? First, approval. What kind of approval we need? Special resolution. But if issue is connected with NCD, non-convertible debt, and if the proposed issue along with existing debt, if it is within the limits of section 180 subsection 1 clause C, that means 100% of paid up share capital free reserve securities premium, then board resolution is sufficient, or else special resolution is required. Next one, identified persons. Identified persons can be up to how many? 200. And this 200 is per security per financial year. While counting 200, you need to exclude qualified institutional buyers as well as employees. Next one, this limit is not applicable to NBFCs, housing finance companies. They need to comply their respective regulations. And offer made to persons in excess of 200 is deemed to be public offer. So here, private placement offer cum application letters shall be sent within 30 days of recording their names. Within 30 days of identifying them, we need to circulate this document among the persons whose names were mentioned in the record. Except to these persons, company should not circulate this document. Company is prohibited from advertising private placement, and company cannot provide benefit of renunciation. And all application monies received shall be deposited in separate bank account, and it can be utilized only for adjustment against allotment or refund of application monies. Note, in case of joint holders, amount shall be paid from bank account of first named person. Recently, I have gone through one case study. In that case study, in one company, it made private placement. It collected all the monies and it kept monies in company's bank account instead of separate bank account. Yes, ROC issued a notice to that company, and the reply from the company is, for opening separate bank account, we need 7 days time and we need funds urgently. And moreover, we made allotment of securities on the same day, and then only we started using funds. Like that, they gave reply. Now, authority, it will check genuinity of the transaction. If it is genuine, okay, urgency is there, and for opening bank account 7 days time period is there. Now authority may release company from those violations. Or else if authority, if ROC thinks that something happened, some conversion of black money into white money, or some ungenuine transactions happen, like that, if authority feel, what authority will order? Authority will order company to refund all those application money within 30 days of order. Getting my point, students? Everyone. So in case of joint holders, amount shall be received from which account? First named person, first named person in the joint shareholding. Next one, can we make new private placement? Yes, provided previous private placement should be either completed or withdrawn. Next one, what is the time limit for allotment? 60 days of receipt of application money. Within 60 days of receipt of application money, we have to make allotment. Or else refund within 15 days after expiry of 60 days. In case of delay, who will pay interest? Company or directors? Company. How much? 12%. From which date onwards? From expiry of 60th day. That means from 61st day onwards, interest calculation will start. Next one, filing of filing of written of allotment with ROC. It is in PAS 3 form. And what is the time limit for filing this form? 15 days. In case of default, company, promoters, directors, whether they are at default or not, immaterial, all these people will get punishment. How much is the punishment? 100 per day during such delay continues up to 25 lakhs. A non-compliance of section 42, then punishment is company, promoters, directors, each person should pay penalty. How much? Amount raised through private placement or rupees 2 crores, whichever is lower. And we had form numbers, we had 5 forms actually. PAS 3 you all know, written of allotment. Information memorandum is in PAS 2. And advertisement for changing the terms of contract or for changing the objects in prospectus, it is PAS 1. Private placement record, PAS 5. Private placement offer cum application letter should be in PAS 4. Out of 5 forms, definitely you can expect a question on PAS 3 only. Remaining forms, if you are able to remember, just remember. Understood? So with this, prospectus and allotment of securities completed. So in this lecture, I am going to revise chapter 4, share capital and debentures. So how many sections we are having in this chapter? 30 sections, 43 to 72. How to remember sections, ma? 2 parts, share capital, debentures. Share capital 43 to 70, debentures 71. And next one, nomination is available for both securities, that is 72. Now coming to share capital, here we are having 4 concepts: basics, issue, transfer, publication. Basics, issue, transfer, publication. Coming to basics, kinds, nature, numbering, 43, 44, 45. You will find all these 3 ingredients in a certificate of share, which is section 46. Next one, holding this share certificate, you will get some rights and you will also get obligations. So rights available because of holding this certificate of share is voting rights, and variation of rights is also possible. And the obligation you are getting because of holding this certificate of share is calls on shares. If you pay any extra amount, it is calls in advance. No voting rights, no extra voting rights for calls in advance, and on calls in advance we will get interest. Now dividends, next one is dividends. So dividends will always be paid on face value. So section numbers: 47 voting, 48 variation, 49 calls on shares, 50 calls in advance, 51 dividends. So next concept is issue. Issue can be happened at premium or at a discount. Next one, issue of preference shares. Issue of shares at premium 52. Issue of shares at discount void 53. Issue of sweat equity shares 54. Next one, issue and redemption of preference shares 55. Next one is transfer of shares. Transfer of shares, section 56. Transfer at par. Par stands for personation, 57. Appeals, 58. Rectification, 59. And next one is publication of capital, 60. This capital can be altered, 61. After alteration of capital, either it may lead to increase of capital or reduce of capital. So increase of capital is happening in 2 ways. One is further issue of shares, 62. Issue of shares at free of cost, bonus shares, 63. Whatever things happen in company, company has to communicate with ROC 64. Next one, reduction of capital 66. Yes, here in reduction two parts. One is liability, other one is capital. So in our syllabus we are not having 65. So 65 is reduction of capital. 66 reduction of 65 reduction of liability. 66 reduction of capital. And capital can be reduced by buyback. Okay. So what are the restrictions for purchase of its own shares? 67. Conditions for buyback 68. Transfer to CRR 69 and prohibition on buyback 70. Is it clear? Next one, starting with section 43. First of all, what is a share? Share means share in the share capital of the company and includes stock. That means the provisions, the chapter 4, the provisions of share capital applies not only to share but also applicable to stock. So what is the difference between share and stock? Share is a unit in the share capital. Share may be partly paid up, fully paid up, and shares can be issued directly. But coming to stock, it is a collection of shares. Transferability point of view, stock is better than share because shares are not available in fractions, but stock is available in fractions. And can a company issue partly paid up stock? No. Can a company issue partly paid up stock? No. So stock should be fully paid up. And company cannot issue stock directly. First it will issue shares. If those shares are fully paid up, then company, on the request of members, company can convert those shares into stock. Which kind of shares? Fully paid up or partly paid up? Fully paid up. So can't be issued directly, conversion of fully paid up shares. Next one, section 43, kinds of share capital. How many kinds we are having? Two kinds. Equity share capital, preference share capital. Equity share capital, it's a share capital other than preference share capital. Preference share capital, it is a share capital which carries either preferential rights or participatory rights or both. Either preferential or participatory or both. Everyone. So preferential rights, compared with equity shareholders, preference shareholders will get priority with respect to payment of dividend, redemption of capital. Participatory right means after payment of equity dividend, whatever profit is available in the company, after settlement of equity shareholders, whatever surplus is there in the company at the time of liquidation of company, in this surplus, which is surplus after settlement or before settlement? After settlement of equity shareholders. In this surplus, who will also get share? Preference shareholders will also get right. So those preference shares are known as participatory rights. Now preference share capital is a share capital. Either it may have preferential rights or it may have participatory rights or it may have both. Clear? Next one. General presumption. If AOA is silent, all preference shares are non-participative, cumulative. Now tell me, preference shares, can a company issue irredeemable preference shares? No. That means company can issue only redeemable preference shares. Suppose if company want to issue convertible preference shares, or if company want to issue non-cumulative shares, if company want to issue participative shares, exclusive point should be provided. So without inclusion of these points, generally preference shares are non-participative, cumulative, non-convertible. Everyone. See, for issue of preference shares, members' approval is required. Special resolution is required. Yes or no? Is this resolution required only for convertible preference shares, or is this resolution required for non-convertible preference shares also? I'm asking you a question. Special resolution is required when, if preference share is a convertible or if preference share is a non-convertible, both the situations we need special resolution. Answer is both the situations, because compared with equity shareholders, these fellows are getting priority. That means whose interest is getting affected? Equity shareholders' interest is getting affected. Any confusion? Everyone. So whether it is convertible or non-convertible, immaterial, we have to take special resolution. Convertible, dilution of control is there. In case of non-convertible, interest is getting affected by way of giving priorities. By way of giving priorities, their interest is getting affected. So in an examination, if a question is asked like this, company is planning to issue non-convertible preference shares, is company required to pass special resolution at general meeting or not? Answer is yes, special resolution is required. Next one, equity share capital, two types. How many types? Normal voting rights, differential rights. Normal voting rights, each share will give you equal voting rights. Each share will give you equal voting rights. In case of poll, 1 share equal to 1 vote, 10 shares equal to 10 vote, provided all these shares are fully paid up. As you all know, in case of poll, a person voting depends on his holding of paid up share capital in the company's total paid up share capital. Suppose this fellow is holding partly paid up shares, and company is having other class which is fully paid up. Now definitely 1 share equal to 1 vote concept will not come. 1 share equal to 1 vote concept comes only when company is having fully paid up shares, fully paid up equity shares. Clear? Coming to differential rights, here 1 share need not be equal to 1 vote. As I told you, differential rights are of two types: inferior voting rights, superior voting rights. Inferior voting rights maybe 10 shares equal to 1 vote, whereas superior voting rights 1 share equal to 10 votes. Now tell me, which shares promoters will take, which shares will public take? Public will take high dividend voting, high dividend rights shares, whereas public will take high voting rights. Understood? So here dividend may be, promoters will take high voting, whereas public will take high dividends. Yes or no? So public will think about this kind of shares because here dividend is high, whereas promoters will take about these shares because for them dividend is not a matter, for them voting rights is a matter. Clear? Okay, next one. For issue of equity shares with the differential rights, company has to satisfy certain conditions. And what are those conditions? MOA default, default MOA. One second. Yeah, company should satisfy conditions. The condition is MOA default. Okay, so for issue of equity shares with the differential rights, company has to satisfy certain conditions. To remember those conditions, I told you default MOA. Default MOA, reverse it off. That means A stands for Articles of Association Authorization. If AOA is silent with respect to issue of equity shares with the differential rights, then alter AOA according to the provisions of section 14. Next one, pass ordinary resolution. Suppose if company's equity shares are listed on recognized stock exchanges, then voting shall be passed through, resolution shall be passed through postal ballot. That means voting shall be conducted through postal ballot. Getting my point? Next one, there is a limit, maximum limit. What is the limit? Voting power from differential rights shall not exceed 74% of total voting power of the company. Total voting power of the company means voting power from normal rights plus voting rights of differential rights. In this total pool of votes, voting rights from differential rights shall not exceed 74%. Clear? Next one, company shall not have following defaults. And for remembering, I classified defaults into two categories: subsisting default, time default. Subsisting default means at the time of issue of equity shares with the differential rights, you should not possess these defaults. And time defaults means for that fixed time period, in past, you should not possess these defaults. Suppose if you take time defaults, again two categories, 3 years, 5 years. Interpretation is like this: 3 years defaults means last 3 financial years, that means 3 preceding financial years, company should not have following defaults. One is ROC filing, other one is not penalized by RBI, SEBI, FEMA, Securities Contract Regulation Act, any other sectorial regulator. Next one, 5 years means from the year of rectification. Here for me time of default is irrelevant. For me here what is relevant? Rectification of default. In which year default was rectified? Excluding that year, 5 years ban. Ban on what? Issue of equity shares with differential rights. So here to remember these two categories, I told you to remember types of finance. How many types of finance we are having? Equity, preference, debentures, deposits, term loans. Okay, except term loans, all the points right under subsisting defaults. So declared dividend, preference share capital redemption, debentures, interest on debentures, deposits, interest on deposits. If you have these defaults, you can't issue equity shares with the differential rights. However, upon rectification, the very next minute you can offer equity shares with the differential rights. 5 years defaults, under this right term loans and interest on term loans. Clear? For 5 years defaults, write term loans, interest on term loans, preference dividend. Next one, employee statutory dues, IEPF transfers. Any default in this, any default in the following cases, first you rectify them. Upon rectification, wait for 5 years from the year of rectification. Are you all getting my point? Everyone. Other conditions, for passing ordinary resolution, definitely we should issue a notice calling for meeting. Along with the notice, you need to attach a document called explanatory statement. In explanatory statement, provide information regarding issue of equity shares with differential rights, issue size, and the specialities, extra voting rights are, extra dividends are, like that. Everything you need to provide in explanatory statement. Next one, conversion of normal rights into differential rights, differential rights into normal rights, allowed or prohibited? Prohibited. Disclosures in board report. Next one, rights of equity shareholders. I told you, differential rights holders, normal rights holders, they will have same rights except voting and dividends. Except voting and dividend matters, all other rights, right to attend general meeting, right to get share in profits, right to be consulted, every right, all shareholders are entitled to, whether he is holding equity shares or different equity shares with normal rights or equity shares with differential rights. If company issues right shares, both will get right shares. If company issues bonus shares, both will get bonus shares. But the point is, if you are holding a normal right, you will get normal right only. If you are holding differential rights, under bonus you will get only differential rights. Interchange, possible or not possible? Not possible. Next one, particulars to be maintained in the registers maintained under section 88. So these are the other conditions, for issue of equity shares with the differential rights. Next one, note, section 53 shall not apply to two companies. What are those two companies? Private company, specified IFSC public company, provided MOA AOA of a company so provides. That means what? MOA AOA shall contain a clause stating that section 43 is not applicable to us. If section 43 is not applicable to us, if section 43 is not applicable to us, if this point is not there in MOA AOA, then section 43 is applicable to specified IFSC public company as well as private company. Very simple, ma. If AOA is silent with respect to section 43, then section 43 is applicable to both the companies. If it provides otherwise, means section 43 is not applicable to us, then section 43 is not applicable only to IFSC public companies as well as private companies. Clear? Everyone. Next, 46, 44, 45, very small sections. What is 44? Nature of shares. What is the nature of a share? The nature is movable property. Similar to goods, you can transfer shares, but transfer of shares is affected by AOA of the company. If your company is a private limited company, yes, definitely there will be restrictions on transfer. If your company is a public limited company, obviously there will be no restrictions on transfer. Clear? 45, numbering. Same numbering or distinctive numbering? Distinctive numbering. I'm talking about numbering of shares. I'm not talking about share certificate. Share is different, share certificate is different. Share means share in the capital. Share certificate means it's a document showing title. In that document, how many number of shares are mentioned, you are owner for those number of shares. So certificate of shares, share certificate means it's a document showing title. Share means, it's a share in the capital of the company. So share means unit of the capital, whereas share certificate means document showing title of the person. Yes or no? Next one, share certificate, it's a prima facie evidence of the title provided it is issued under common seal of the company. No common seal, then two directors has to sign share certificate. In case company is having secretary, then one director and one secretary has to sign certificate of share, then only certificate of share is valid. Because of share certificate, company cannot deny ownership of the member. Company cannot increase the liability of the member. On the share, suppose face value 10 rupee, paid up value is 10 rupee. Now what is the liability of member? 0. Company cannot increase liability of the members by issuing share certificate. First one, no deny of ownership. Second one, no increase of liability. With respect to demat form of securities, record maintained by depository is a prima facie evidence that you are owner of the shares. If shares are in material form, then what is the prima facie evidence of title? Share certificate. Everyone. Now this section 46 is not only talking about original share certificate, it is also talking about duplicate share certificate. See, duplicate share certificate arises in two cases: when original certificate is lost or destroyed, or it is damaged or torn. In case of lost or destroyed, your application should be supported with indemnity bond. In case of damaged or torn, your application should be supported with original share certificate. And you know, these share certificates are in which form? SH1. And for getting duplicate share certificate, you need to deposit a fees not exceeding 50 rupees per certificate. Rupees 50 or AOA, whichever is lower ma. Rupees 50 or rate mentioned in AOA, whichever is lower. And disclosure is very important. On duplicate share certificate, a clear-cut disclosure of, you know, this share certificate issued in lieu of original share certificate number. So this disclosure is important. Next one, what is the time limit for issue of duplicate shares ma? Sorry. What is the time limit for issue of duplicate share certificate? 45 days in case of listed company, 3 months in case of unlisted company. Everyone? Next one, register. Maintain register in form SH2 with respect to duplicate share certificates. Next one, entries. Who will authenticate entries in this register? Either company secretary or authorized person. Who will authorize that person? Board. Any person authorized by board. So simply board authorized person. Clear? Next one, issue of duplicate share certificate with an intent to defraud. Then punishment. Officer in default will get punishment under section 447. Whereas company minimum fine how much? 5 times of face value of shares. Maximum fine 10 times of face value of shares or 10 crores, whichever is higher. This higher limit is there only for maximum fine. Don't get confused ma. Minimum it is, you know, not less than 5 times of face value of shares, and it is it will be extended up to 10 times of face value or 10 crores, whichever is higher. This is all about section 46. Next one, 47, voting rights. 47, voting rights. So here, you know, shares, kinds of shares. How many kinds we are having? 2 kinds. Equity, preference. Who will get voting power on all resolutions in general meeting? Equity shares. And who will get voting rights on, you know, matters affecting their rights? Winding up of the company, reduction of the capital, preference shareholders. And if preference shares dividends are not paid for a period of 2 years or more consecutively, then preference shareholders will also get voting rights in addition to equity shareholders. And once you discharge their dividends, once you pay those dividends, you know, then dividends not paid concept will not rise. That means their voting rights will be stopped. Everyone. So in case of show of hands, 1 member, 1 voter, 10 votes are 1 vote. In case of poll, equity shares with voting rights, normal voting rights, 1 share equal to 1 vote, provided every share of the company is fully paid up. Equity share with the differential rights, it depends on terms of issue. Next one, this is very important point. Everyone told wrong answer. Everyone told wrong answer when we solved that multiple choice question. In case of Nidhi company, voting power of a member is restricted to 5%. Suppose if he is holding 1% paid up share capital, 1% voting right. 2% paid up share capital, 2% voting rights. 10% paid up share capital, voting right is restricted to 5%. Clear? And section 47 shall not apply to IFSC public company, private company, provided MOA, AOA contains the same. If MOA, AOA provides otherwise, then section 47 is not applicable to these 2 companies. Clear? Everyone? 47 completed. Next, 48. What is 48? Variation of shareholders' rights. Variation of shareholders' rights. 4 points you need to remember under section 48. One is, variation is permitted only if these 2 conditions, any of these 2 conditions are satisfied. But before that, you know, this section is not applicable to all companies. This section is applicable to companies having share capital which is divided into different class of shares. This is important point ma. Companies having share capital which is divided into different class. Suppose if company is having same class of shares, so variation, you know, general meeting will take care of it. I told you, you know, company had equity shares and company issued preference shares. So preference shares, you know, 10% preference share capital redeemed after 10 years. Now what is the right of a preference shareholder ma? Every year he is entitled to 10% dividend, and after 10 years he is entitled to capital. Now if you are changing the rights of preference shareholder, then section 48 is applicable. So company should have a share capital and it is divided into different classes of shares. Everyone. So what is the first condition for applying section 48? The first condition is company should have a share capital and it is divided into different classes. Next one, you need to check constitutional documents of the company, that is MOA, AOA. So MOA, AOA should authorize variation of shareholders' rights. If MOA, AOA is not having any authorization, then go with issue terms, go with issue documents, either prospectus or, private placement or, letter of offer in case of rights issue. So in these issue documents, there should be no prohibition on variation. Either of these two conditions should be satisfied, either authorization in constitutional documents or no prohibition in the issue documents. Once second condition is satisfied, then proceed with a consent of shareholders. Whose consent I should take? The persons whose rights is getting affected. So if it is preference shareholders, then preference shareholders, I need to take consent of preference shareholders. How much consent I need? 3/4 value, not 3/4 of the holders, 3/4 of the value holders. Maybe 1 in number, 2 in number, but the persons who is giving consent to the persons who are giving consent to the variation, they should possess 75% of the capital. And next one, if variation of one class is affecting the rights of other class, then you need to take a similar consent from other class members. Next one, dissenting shareholders can file an appeal with NCLT, but they should possess at least 10% of that class capital. And if they want to file appeal, that appeal should be filed within 21 days. With whom they can file appeal? NCLT. Now who will decide whether to confirm the variation or to cancel the variation? NCLT. So now whatever order passed by NCLT, it is final and it is the duty of company to file NCLT order with ROC within 30 days. Clear? Everyone? That is all about section 48. Yeah, this word if company is able to call for a meeting, then special resolution is sufficient. If voting is conducted through postal ballot, then at least 75% of issued shares holders consent is required for variation. Everyone, so just remember this limit just remember this limit. In examination they can ask you like this: by passing ordinary resolution or by taking consent of majority of the capital holders, company proceeded with variation of shareholder rights. Is it valid or not valid? Answer is not valid. Can I proceed? Next one, section 49 to 51, small sections. Last attempt, on the small sections, 5 marks question came. Yes or no? So calls, who can make calls on shares? Who can make calls on shares? Board of directors, and that call should be on uniform basis. So calls on shares should be supported by board resolution, and that call should be on uniform basis. Calls in advance, yes, company can accept advance money which was not called. For that, AOA authorization is required, and company is liable to pay interest. How much is the interest rate mentioned in AOA? And with respect to calls in advance, extra voting available or not available? Why? Voting rights depends on paid up share capital, and paid up share capital includes calls in advance or excludes calls in advance? Excludes, because calls in advance is a liability, it is not a capital. So therefore it is not included in the paid up share capital, therefore no extra voting rights. Since calls in advance is not included in paid up share capital, no extra voting rights. Clear? Next one, payment of dividend. Normally whenever company declares rate of dividend, that rate of dividend we need to apply on face value or paid up value? Face value. But if company is authorized by AOA to pay dividends on paid up value, then company will declare and pay dividends on paid up value. Understood? So for declaration of dividend on paid up value, authorization from AOA is required. Everyone? Next, section 52, utilization of securities premium. Application of securities premium. Do we need AOA authorization for issuing shares at premium? Do we need AOA authorization for issue of shares at premium? See, we need AOA authorization for issue of shares, but we don't want any AOA authorization for fixing premium amount. And there is no restriction on fixing premium amount. Clear? Premium amount is at the discretionary powers of the directors. But here Companies Act 2013 is placing restrictions on utilization of securities premium. Securities premium can be utilized only for 5 stated purposes: bonus shares, buyback, issue expenses. Issue expenses means expenses connected with issue, like discount, underwriting commission. Discount. Next one, underwriting commission. Next one, premium on redemption of securities, maybe preference shares, maybe debentures. Next one, right of preliminary expenses. If you are a company covering under section 133, if you are a company preparing financial statements in accordance with the accounting standards, then utilization of securities premium is restricted to 3 purposes. One is bonus, buyback, expenses connected with issue. Clear, everyone? Next one, if you utilize securities premium for any other purpose, then instead of deducting securities premium amount, you need to deduct capital. For that, section 66 shall apply. Reduction of capital provisions shall apply. Can I proceed? Next one, prohibition on issue of shares at discount. Tell me, can a company issue shares at discount? No. What is the general rule? Issue of shares at discount is void. However, we had 2 exceptions. One is sweat equity shares by complying with the directions of section 54. Next one, debt converted into equity as a result of statutory resolution plan or debt restructuring scheme which was prepared in accordance with RBI guidelines. Other than these 2 purposes, if company issue shares at a discount, it leads to violation of section 53. Punishment, for company as well as officer in default, punishment is 5 lakhs or amount raised through issue of shares at discount, whichever is lower. In addition to this, they need to refund all those monies along with a 12% interest. Any doubt? Next one, rate of interest is also important from MCQ point of view. Next one, sweat equity shares. So sweat equity shares, these shares can be issued either at a discount or for a consideration other than cash. To whom? To the directors or employees of the company, holding company, subsidiary company, whether working in India or outside India, for providing know-how, intellectual property rights, value additions. So what are the conditions for issue of sweat equity shares? I told you to remember conditions. The cheat code is SWEAT. S stands for special resolution. For getting special resolution, yes, we need to give notice calling for meeting. Along with notice, we should give explanatory statement. In explanatory statement, we provide this information. What is the current market price of the share? To whom we are offering a sweat equity shares? And what consideration we are getting from them? And company is prohibited from issuing sweat equity shares up to 1 year of incorporation. But this condition, there or not there? Not there. I cancelled this condition. Previously, when Act came into the picture, 1 year after incorporation only company can issue sweat equity shares. That condition is there. But right now, that condition is deleted. Next one, in case of listed company, comply SEBI. In case of unlisted company, comply Companies Act. And existing class of shares shall be issued as sweat equity shares. So can a company issue sweat equity shares, from a new class of shares? No. Only from existing class they can offer. That means already issued shares. Already issued shares. Suppose some 5% balance is there. 5% of that class, it was unissued. Now you can offer those shares. But from new class of shares, you cannot offer sweat equity shares. Everyone, you can't allot sweat equity shares from new class. You can allot sweat equity shares from existing class. Sweat equity shares rank, sweat equity shareholders rank pari passu with other shareholders. That means what are all the rights and benefits, other shareholders are entitled to. For the same rights, sweat equity shareholders are also entitled to. Next one here, employee means permanent employee or temporary employee? Permanent employee. Director, whether whole time or not, working in our company, subsidiary company or holding company, either in India or outside India. And some special note points. Sir, within what time period I should complete issue of sweat equity shares? 12 months from the date of special resolution. And what is the limit on sweat equity shares? In a year, company can issue sweat equity shares up to 15% of existing paid up share capital or rupees 5 crores, whichever is higher. But during the lifetime of the company, sweat equity shares shall not exceed 25% of existing paid up equity share capital. Everyone, Whereas for startup companies up to 10 years of incorporation, the limit is not 25%, the limit is 50% of paid up equity share capital. Everyone? Everyone. And what is the lock-in period? 3 years from the date of allotment. 4 years, 5 years, not permitted. You know what is the lock-in period? 3 years. Valuation of shares. You know who will value the share? Registered valuer. Who will value IPR, know-how and value additions? Registered valuer. So based on this, company can proceed with accounting, accounting treatment. If company is getting depreciable asset because of employee efforts, then carry it to balance sheet. If nothing is getting, that means, we are not getting any asset, we are not getting any intellectual property rights, we are not getting any know-how things. In that case, record it as an expenditure, charge to profit and loss account. Clear? Everyone? If those shares are given to the directors, then it is considered under remuneration paid to directors. If it is paid to normal employees, then it will be considered as employee benefit expense. Any doubt? Next one, disclosures in board report, maintenance of registers. Separate disclosures are required in the registers regarding sweat equity shareholders. So with this 54 completed, one page, all points I covered. Okay. Next one, 55. Issue and redemption of preference shares. Section 55 is dealing with two things, not only issue but also redemption. And here redemption includes deemed redemption. That means redemption means actual redemption as well as deemed redemption. For issue of preference shares, what are the conditions a company should satisfy? It should get authorization from AOA, special resolution by its members, equity shareholders, and no subsisting default at the time of issue of preference shares. What defaults are? Payment of preference dividend, redemption of preference capital. With these defaults, come on, tell me, can a company issue sweat equity shares? No. And company can issue only redeemable preference shares. And what is the maximum tenure of the preference shares? 20 years. For infra companies, it's not 20, it's 30 years. Everyone, 30 years. Whereas redemption shall happen from 21st year onwards, minimum 10% every year. So these are the conditions for issue of preference shares. And what are the conditions for redemption of preference shares? First of all, shares should be fully paid up. Redemption of partly paid preference shares, allowed or not allowed? Not allowed. Redemption is allowed only when preference shares are fully paid up. And in this redemption, we are having two components. One is nominal value, other one is premium. For nominal value, that means face value, company can utilize its divisible profits, or it can utilize issue proceeds of shares. If company decides divisible profits as an option for redemption of preference shares, then nominal value of shares so redeemed shall be transferred to CRR, and CRR shall be utilized only for one purpose. That one purpose is issue of bonus shares. Next one, for premium on redemption, yes, company is having two alternatives. One is two sources. For redemption of, for premium on redemption of preference shares, company is having how many sources? Two sources. Company profits, securities premium. However, securities premium source is not available to companies which are covered under section 133. That means companies which are preparing financial statements in accordance with accounting standards schedule 3, as you all know, for them securities premium option is not available for premium on redemption of preference shares. Can I? Next one, issue of further redeemable preference shares. Issue of further redeemable preference shares. See, when this situation, arises, maturity date came, but company is not in a position to redeem preference shares. Company is not in a position to pay preference, company is not in a position to redeem preference shares. In that case, what is the outstanding capital and what is the dividend due? Just calculate it. Covering those two amounts, company can issue new shares. But for that, company is required to get consent of preference shareholders. How much consent? 3/4 value. 3/4 value holders. That means 3/4 of the capital holders. From them we need to get consent. Next, proceed with application with NCLT. NCLT will give approval provided dissenting shareholders shall be redeemed. Now, because of this deemed redemption, any increase in preference share capital or any reduction of share capital, we are not going to apply increase reduction of share capital provisions here. I told you existing preference share capital 20 lakhs. Dividends outstanding, for example, cumulative shares, dividends due is 2 lakhs. Now you can issue shares up to 22 lakhs. So if you observe carefully, existing capital is 20, now it is becoming 22, but this is not increase. This is not to be considered as increase. Next, suppose out of 22 lakhs, I got permission only from 80% of the capital holders. And I didn't get consent from 20%. So for 20%, what I'm doing? I'm doing actual redemption. Understood? So 80% means 22 lakhs into 18% means 80% means maybe 17.6 lakh. So now I am issuing preference shares covering which value? 17.6 lakhs. So if you observe, what is my original capital? 20. And what is the result after issue of further redeemable preference shares? 17.6. So if you observe, there is a reduction of capital, but reduction of capital provisions shall not apply here. Everyone, in one attempt, a question came on this concept. So company is not in a position to redeem its preference shares. What alternative company is having? Advice board of directors. So what company can do? With the consent of 3/4 of the value holders and with the approval of NCLT, company can convert existing preference shares into new preference shares. So issuing further redeemable preference shares. NCLT will give approval subject to redemption to dissenting shareholders. Can I? 55 also completed. Next one, 56. What is 56? Transfer and transmission of securities. How many parties are required for transfer? 2 parties. One is transferor, other one is transferee. What is the effect of transfer, ma? What is the effect of transfer? Transferor voting percentage or transferor holding percentage, either it will be reduced or it may become 0. Voting depends on holding, so I'll use word holdings. So transferor holding may be reduced or transferor holding may come to 0. And because of transfer, transferee holding may be increased or transferee may become member of the company. If he is already an existing member, his holdings will be increased, or if he is not member before transfer, then he can become member because of transfer. And for transfer, certain conditions we need to satisfy. One is, first of all, what can be transferred? Securities in case of company with share capital, interest in case of company without share capital. And for transfer, certain conditions we need to satisfy, that is execution of transfer instrument. It is in form SH4. Who will execute this instrument? Transfer or transferee. And it should be dated and stamped, signed by both transferor and transferee, delivered to company within 60 days of execution. In case of loss of transfer instrument, or in case submission of documents happened after 60 days, then on indemnity bond provided by the parties, company may register transfer of securities. So this concept, this transfer is not applicable to these 3 things. One is shares in demat form in case of transmission, and bonds by government companies. So for these 3, in these 3 cases, section 56 is not applicable. As you all know, government company should be regular in complying with the provisions of 92, 137. 92, filing of annual returns. Section 137, filing of financial statements. Any confusion? Clear, everyone? Next one. One point, okay. Under section 55, there is one more point. However, that point is already covered in 64. As you all know, whenever redemption happens, company has to file a form with ROC. According to which section? 64. So okay, I will discuss that point at that point. Now we are discussing about 56. Next one, in case of partly paid up securities where application is executed by only transferor, application is filed by transferor alone, then company shall not register transfer unless it gives 2 weeks notice to transferee. 2 weeks notice means from the receipt of notice, if transfer is having any objection, he should file an objection with company within how many weeks? 2 weeks. If there is no response, if there is no objection from transferee, then company shall proceed with the registration of transfer of partly paid up securities. Legal representative is having 2 options. Either he can select a transmission option, that means he himself register as a member. He register himself as a member. Or he is having another option, that another option is transfer by execution of SH4. He can transfer to others. So 2 options are available. Next one, time period for delivery of certificates. time period for delivery of certificates. If you are a subscriber to MOA, you should get share certificate within 2 months from incorporation. If you are an allottee in case of allotment of shares, then you should get share certificate within 2 months from allotment. That means, company is having a duty to issue share certificate within 2 months from incorporation, within 2 months from date of allotment. In case of transfer or transmission of securities, it is the duty of company to issue security certificate within 1 month from the receipt of instrument or from the receipt of intimation request. In case of allotment of debentures, it is 6 months from allotment. It is the duty of company to issue debenture certificate within 6 months from allotment. And for specified IFSC companies, 60 days. 60 days. So incorporation, allotment, transfer, transmission, everything, the date is 60 days. The due date is, the time limit is 60 days. Can I? Next one, penalty for non-compliance of provisions of section 56. For company and officer in default, 50,000, and for depository in case of fraud, it is 447. Wherever you read word fraud, immediately one section will come. What is that section? 447. Next, 57, punishment for personation of shareholder. Punishment for personation of shareholder. Any person fraudulently, that means, deceitfully, personates owner of any security or any interest in a company without share capital or share warrant or coupon, and obtains or attempts to obtain security, interest, share warrant, coupon, any money dues on those certificates, any money due on those coupons, share warrant, shares, then imprisonment will be 1 year to 3 years and fine 1 lakh to 5 lakhs. So two conditions to be satisfied. One is, deceitfully personates and obtains or attempts to obtain following things: security, interest, share warrant, coupon. I'm using the word C. Security means it is applicable to company with share capital. Interest means company without share capital. Getting everyone? Next one. So what is the punishment? Imprisonment 1 to 3 years. Fine 1 to 5 lakhs. 1 to 5 lakhs. Chance is there. This provision can be tested for 3 marks. Chance is there. So far not yet asked. So they may ask you either in multiple choice question 2 marks or descriptive question 3 marks. First they will narrate the story according to these conditions, and they will ask you to write consequences. So now it is very important to remember punishment. Yes or no? Okay, fine. Next one, forged transfer. Forged transfer means here transfer or signature is valid or forged? Forged. And what is the effect of forgery? Null and void. It is void ab initio in fact. That means, is that instrument of transfer valid or invalid? That means ownership will be with whom? Original owner. It is the duty of company to restore his membership, and it is the duty of company to pay all the benefits to the original owner. Next one, forged transferee. He is liable to indemnify company. And innocent transferee, that means, forged transferee means he is getting shares from original owner, and forged transferee is selling shares to innocent transferee. In this case, innocent transferee will have a right to claim compensation from company. That means company is having a duty to compensate innocent transferee. So company point of view, company is liable to original owner, and if shares are transferred to innocent transferee, then company is also liable to innocent transferee. Whatever damages, whatever losses company incurred, company can claim those losses from forged transferee. Hello everyone. Next, 58. What is section 58? A refusal of registration of transfer or transmission and appeal against refusal. So here company, it's the duty of company to issue notice of refusal to transfer or transferee and a person making intimation of transmission. Within how many days? 30 days. If reason is okay, no problem. If reason is not okay, then transferee or person making an intimation for transmission can file an appeal with NCLT. And what is the time limit? If he is receiving notice of refusal, it is 30 days from notice of refusal if he is a member of private company, 60 days if he is a member of public company. In case of no notice of refusal, then within 60 days of delivery, in case of private company, delivery means delivery of documents for registration, delivery of instrument of transfer, or delivery of intimation for transmission. So delivery means submission of documents with company. 60 days of delivery of documents with company in case of private company, 90 days of delivery in case of public company. Everyone. Next one. Now NCLT is having following powers. Either it may dismiss the appeal or it may order company to register, transfer or transmission, and it is the duty of company to comply the order within 10 days of NCLT order. Any contravention, the person who is responsible for contravention, imprisonment 1 year to 3 years and fine 1 lakh to 5 lakhs. So this is all about section 58. Next 59, rectification of register of members. Rectification of register of members, this comes into the picture because of wrongful inclusion of person as a member, or wrongful omission of a member details from register of members, or companies making unnecessary delay, unwanted delay in updating the registers. Now aggrieved person or member or a company can file an appeal with NCLT or competent court outside India in case of foreign registers. If that mistake is in foreign register, if foreign member wants to file an appeal, he can file appeal with whom? Competent court in India or outside India? Outside India. Now NCLT or competent court outside India is having following powers, either to dismiss the appeal or order company to rectify the register. So comply the directions ma. And one more point, 58, for filing appeal there is a time limit, 30 days, 60 days, 60 days, 90 days, time limit is there. Whereas for section 59, time limit is not available, but application shall be filed within reasonable time. And there will be no restriction on transferee rights unless voting rights are suspended by NCLT. Once appeal is filed with NCLT, until that appeal is closed, there will be no effect, no restriction on rights of the transferee. Suppose if NCLT suspends voting rights of the transferee, then transferee cannot exercise voting rights at a general meeting. Everyone, not only general meeting but also postal ballot. Can I proceed? Can I? Next, section 60. If you are publishing authorized share capital on any official publications, in addition to paid up authorized share capital, you need to publish subscribed capital as well as paid up share capital. If you are advertising your authorized share capital, then it's your duty to advertise subscribed share capital as well as paid up share capital. Default, company 10,000 rupees, officer in default 5,000 rupees per default. Of course, section is not there in our syllabus, small section I told you. Next one, 61. What is 61? Alteration of capital. Power of limited company to alter its share capital. What are the conditions? 3 conditions. AOA authorization, ordinary resolution from members, ROC filing. And in how many ways I can alter capital? In 5 ways. Either I can increase or decrease, or I can consolidate and divide, or I can split, or I can convert shares into stock, reconversion of stock into shares. But in case of consolidation and division of shares, if there is any change in voting powers of the members, then prior consent of NCLT is required. Without prior consent of NCLT, consolidation and division is not possible where voting rights of the members is getting affected. Everyone? Okay. Next one, section 62. What is section 62? Further issue of share capital. Of course, not applicable to Nidhi company. Issue of further shares. How many options I am having? I'll go with existing members, or I'll go with employees, or else I'll go with others. Others, again 2 types. Identified persons, this benefit is available to both private companies and public companies. Can OPC select this option of others? Can OPC select the option of employees? No. Why? Minimum and maximum number of persons in OPC shall not exceed. Maximum number of persons in OPC shall not exceed. Minimum it shall not fall below 1. If it is falling below 1, nominee becomes member. If they want to increase number of members, then section 18, conversion of companies. Hello? Okay. So yes, in case of others, 2 options. One is identified persons, available to both private company and public company. Next one, the second category is public at a large. Of course, public at a large is available only with public companies. For that, you need to comply which chapter rules? Chapter 3, prospectus and allotment of securities and rules made thereunder. Understood? If you're going with existing members, prepare a document called a letter of offer. Dispatch this letter of offer at least 3 days before opening of offer. And offer period is minimum of 7 days, maximum of maximum of tell me, maximum of 30 days. Actually minimum 15 days or such lesser number of days as may be prescribed. As per rules it is 7 days, maximum it is 30 days. Clear? Next one, of course this time period can be reduced in private limited companies with 90% consent of the members. Next one, renouncement, available or not available? Available. Default available. Publish the same in letter of offer. If company articles is prohibiting renouncement, then renouncement benefit is not there. And of course in case of private company also, renouncement is restricted, because you can't go with public, yes or no. Suppose I am giving offers to you, and if you are renouncing it to others, what happens? Indirectly I am issuing shares to whom? Public. Private companies are prohibited from inviting offers, inviting from public for subscription of its securities. Yes or no? Everyone, voice okay? Clear? Next one. With respect to employees, obtain special resolution. But if you are a private company who is complying, which is complying section 92 annual returns, section 137 financial statements, no need of SR, OR is sufficient. Understood? Same with IFSC public companies. Next one, others. For going with others, special resolution and valuation report of the registered valuer is required. Next one, these above provisions, that means offer to existing members. Next one, offer to the employees. Next one, offer to the others. When you are going with others, what type of resolution we need? Special resolution. But this is not required in case if you are giving shares to whom? Debenture holders because of convertible option, preference shareholders because of convertible option. So in case of convertible debentures and convertible preference shares, at the time of conversion, special resolution required or not required? Not required. Why? At the time of issue only we have collected, we have taken special resolution from members, equity shareholders. Everyone? Next one, even in case of compulsory conversion of debentures which were issued to the government or loans taken from the government into equity, for that also special resolution is not required. Sir, my authorized share capital is not permitted for increasing this capital, sir. My authorized share capital is not sufficient for conversion of debt into equity, sir. No problem. Government order itself is sufficient for increasing the authorized share capital to the extent of conversion. And of course, government will pass an order, central government will pass an order after considering public interest, financial position of the company, terms and conditions of the debentures as well as loans. Everyone? If company is not agreeing with NCLT, then if company is not agreeing with government order, then company can prefer appeal with NCLT within 60 days of government order. Can I proceed? So with this section 62 completed. Section 62 completed. Next one, 63. Issue of bonus shares. What is the other name for issue of bonus shares? Capitalization of profits. So what are the conditions a company should satisfy for issuing bonus shares or for capitalization of profits? First one, limited sources. For issue of bonus shares, you can use only 3 amounts. That means free reserves, securities premium, CRR. Can I utilize the revaluation reserve for issuing bonus shares? No. Next, conditions, AOA authorization, board resolution and members resolution, ordinary resolution. And it is very important to remember this point. Once board made a recommendation of bonus issue, it can't be withdrawn subsequently. So board resolution, next members approval. And at the time of issue of bonus shares, company shall not possess these defaults. What are those defaults? Interest on deposits, interest on debt securities. Deposits principal amount, debentures principal amount, employee statutory dues. So company should not commit following defaults at the time of issue of bonus shares. Company should not have these defaults. Company should not have these defaults at the time of issue of bonus shares. Next one, issued shares shall be fully paid up bonus shares, and the persons entitled to bonus shares, they should also hold fully paid up bonus, fully paid up shares. Listen carefully, ma. Listen carefully. Who is entitled to bonus shares? One small adjustment, yeah. So what type of shares I can offer under what type of shares I can issue under bonus shares? Fully paid up, partly paid up. And to whom I can issue bonus shares? Persons holding fully paid up shares, persons holding partly paid up shares, holding fully paid up. On the date of bonus issue, suppose if any person is holding partly paid up shares, convert them into fully paid up by making calls on shares. Once partly paid up shares are converted into fully paid up, then company can offer bonus shares. So that means very simple. Issuing shares should be fully paid up. Recipient, the person receiving bonus shares, should also possess fully paid up shares. And bonus shares shall not be issued in lieu of dividend. Okay. 63 also completed. Every point I discussed. Next, 64. So 64 arises in three situations. One is section 61, whenever company alters its capital. Section 55, whenever redemption of preference share capital is happening. Section 62, whenever government is passing an order to convert a debt or loans into equity. Understood? Next one. What is the applicable form? SH7. What is the time limit for filing this form? 30 days of the event. 30 days of the event. In case of default, company 500 per day up to 5 lakhs. 500 per day. During such default continues, maximum 5 lakhs. Officer in default, 500 per day. During such default, maximum 1 lakh. Everyone, how to remember this punishment? How to write this punishment in examination? 500 per day during default, during continuation of default. If default is continued for 10 days, then 10 into 500, 5,000. 100 days, 50,000. 200 days, 1 lakh. Getting my point? So 500 per day during such default continues, maximum 5 lakhs. Like that you need to write. In examination hall, in examination, don't write minimum or maximum words. Instead of writing minimum word, maximum word, just write like this: not less than and not exceeding, or write word up to. If you are confident about numbers, just write it in numbers. If you are not confident with numbers, write it in letters, words. Everyone? Okay, next one. 65 not there in our syllabus. 66, reduction of share capital. Of course, not applicable to section 68, buyback. Reduction is different, buyback is different. Reduction of share capital is possible in how many ways? 3 ways. One is cancellation of unpaid capital. Uncalled capital, unpaid capital. Next one, cancellation of unrepresented capital, the capital which is not available in the form of assets. Next one, cancellation of unwanted capital. That means, amount in excess of wants. Whatever amount we need, we are having more amount. Suppose we need 10 lakhs, but we are having 12 lakhs. In that case, pay off that excess amount, and maybe you can cancel that unwanted capital. If you cancel unwanted capital, unrepresented capital, there may be extinguishment of liability of members, or there may be reduction of liability, or there may be, without extinguishment, without reduction of liability also. I told you, face value 10 rupee, paid up value 8 rupee. If I am reducing this 10 to 8, then members liability becomes 0. It is nothing but extinguish. Suppose if I am reducing this face value 10 to 9 and my paid up value is 8 rupees, 9 minus 8 how much? 1. What is my original liability? 2. But now my liability is getting reduced to 1. So reduction. Next one. So what are the conditions a company should satisfy for reduction of capital under section 66? So the conditions are, first of all, this section is applicable only to 2 companies. How many? 2. What are those companies? Limited by shares, limited by guarantee with share capital. And that company shall not have following defaults. That is, repayment of deposits, interest on deposits. Understood? Everyone? And it has to file an application with NCLT. Along with application, it has to submit copy of special resolution, copy of minutes of the meeting, list of creditors, auditor's certificate regarding accounting treatment in books of accounts. Now after receiving that application, what NCLT will do? Immediately NCLT will send a notice to 4 persons, CG, ROC, SEBI creditors. And NCLT will give time of 3 months for making representations. If no representation is made by these parties within 3 months, then NCLT will proceed with a confirmation of reduction. By passing an order, it will confirm reduction. But before passing order, it will ensure that all creditor dues discharged or properly determined and secured and they were consented. That means approval of creditors is there. And it will also check auditor's certificate regarding accounting treatment in books of accounts with respect to reduction of capital. And then it will pass an order. Immediately after getting this order, publish this order in 2 newspapers. And also file NCLT order with ROC. Register NCLT order with ROC within 30 days of receipt of order or 30 days of date of order of NCLT. That is certified copy of NCLT order and minutes approved by NCLT. In that minutes you will find what is the revised share capital, how many number of shares there, and what is the reduced what is the revised face value and what is the revised paid up value. The difference between revised face value and revised paid up value is the maximum liability of the members subsequent to reduction. Everyone? Now if company commits any of these errors in the process of getting approval of NCLT, if company commits these errors, what errors? Concealment of creditor. A creditor is entitled to object reduction of capital, but that creditor name you didn't mention in the list. Concealment of creditor, or company made a default under provisions of IBC. Then what liability members will get? Persons who are members at the time of registration of reduction of capital with ROC gets their original liability. So before reduction, what is their original liability? That liability comes into the picture, and not present members. Not present members. Present members will not get this liability. Persons who are members at the time of registration of NCLT order with ROC, only those persons will get this punishment. In fact, it's not punishment. Get back to their original liability. Whether company is active, whether company is doing business, or whether company got liquidated, these people are liable. Next one. And a officer, director who made this kind of frauds, concealment of creditors, misrepresents nature of creditor. Suppose he is a secured creditor, but we are showing him as a unsecured creditor. Suppose his amount due is, amount due to that person is 20 lakhs, but we are showing it as 20,000. Next one, any director who abets or privy to above frauds, then these directors will get punishment under section 447. I'm not punishing all the officers, I'm not punishing all the directors who are responsible for default. But here default means we are writing in detail the person who is responsible for concealment of creditor, the person who misrepresents the nature or the amount of the creditors, and the person already aware of these facts, if he is not opposing these frauds, then that person also gets punishment under section. Actually, who will get that punishment? Company has to file application with NCLT, yes or no? That application will be signed by authorized representatives of the company. So those people are responsible. Section 66 also completed. Single page, single section. Can I? 67. What is 67? Restrictions on purchase by company or giving of loans by it for purchase of its shares. Here 3 points you need to remember. Company limited by shares, company limited by guarantee with share capital. This section is applicable only to 2 companies, and if you remember, these 2 companies are common in above section also. In above section 66 also I talked about these 2 companies. So they have no power to buy its own shares unless reduction of capital is affected. Unless reduction of capital is affected, that means 68, unless 68 is complied, no problem. If section 68 is complied, no problem. 68 is not complied, then 67 comes into picture. So as per section 67, no power to buy its own shares. Next one, this section is not applicable to, come on, tell me, this provision is not applicable to Nidhi company. Next point, no public company directly or indirectly loan, guarantee, security, financial assistance to any person for purchase or subscription of the company shares. So directly or indirectly it cannot finance anyone, it cannot guarantee any person, it cannot provide security to any person so that the person is purchasing or subscribing the shares of the company. Not only our company but also holding company. Understood? But to this rule we had how many exceptions? 3 exceptions. For banking company, as long as it is doing a business, as long as it is giving loans under ordinary course of business circumstances, ordinary course of business, then banking companies are exempted under this section. Next one, scheme. Under a scheme, company can finance a trustee, but for that scheme, special resolution is required, and that scheme is for the benefit of employees, and the scheme, the trustee is acquiring only fully paid up shares. In case of listed companies, the trustee can acquire shares from stock market. Purchase of shares can be happened at stock market. In case of unlisted companies, valuation should be done, at what price. In case of, listen carefully, for acquisition of shares, definitely we need to pay price, yes or no. In case of listed company, price prevailing at stock market is sufficient. For unlisted companies, valuation is required. Next one, maximum restricted to how much 5% of paid up share capital plus free reserves. You can finance this much amount only. And another exception is employees. Employees, here employee excludes KMP, director. Maximum how much finance we can provide? 6 months. And the shares he is acquiring should be fully paid up. If all these conditions are satisfied, then section 67 applicable or not applicable? Not applicable. Next one, this section will not have any effect on redemption of preference shares. Suppose what first point is telling, company has no power to buy its own shares. But under preference shares, under section 55, company is having a duty to redeem preference shares upon completion of tenure. Now there is a conflict between these two provisions. So which one will prevail? Section 55 will prevail. That means no effect of section 67 on section 65. 55. I told 65. Okay. So no effect of section 67 on section 55. In case of contravention, company 1 lakh to 25 lakhs, officer in default, imprisonment up to 3 years, fine 1 lakh to 25 lakhs. Next one, of course this section is not applicable to private company, where in that private company no body corporate is a member, and borrowings of a private company, total borrowings of a private company from banks, financial institutions, from other body corporates, less than or equal to or less than 2 times of paid up share capital or 50 crores, whichever is less, and there is no subsisting default in above borrowings repayments. So this section is not applicable to private company as well as specified IFSC public company. Each and every point, if it is a limit or time limit, monetary limit, statutory limit, everything I'm revising. Next one, last but one concept, 68, power of company to purchase its own securities. So that means buyback. So buyback is possible only from the following sources. For making buyback, amount comes from following sources. What are those sources? Free reserves, securities premium, issue proceeds. But shares involved in issue proceeds and shares involved in buyback, should they belong to same class or different class? Shares involved in issue, shares involved in buyback, shall they belong to same class or different class? Different class. So note, shares in buyback, shares involved in issue should not be same. And if you are selecting free reserves, securities premium for making buyback of securities, then nominal value of shares so bought back shall be transferred to CRR. Everyone. Next, conditions for buyback. First condition, we need AOA authorization. Next one, resolution. See, this resolution I am asking only for what? Buyback amount, not buyback number of shares. In a year, maximum I can make buyback up to 25% of paid up equity share capital. But for financing this buyback, if that amount is less than or equal to 10% of paid up equity share capital plus free reserves plus securities premium, board resolution is sufficient. And if the finance amount is exceeding 10%, but up to 25% of paid up share capital plus free reserves plus securities premium, special resolution is required. Now tell me, with a special resolution, can I invest 30% of capital plus free reserves plus securities premium for financing buyback? 30%, not possible. Maximum 25%. Number of shares, quantum of shares, how many shares I can make buyback in a year? 25%. And what is the post buyback debt equity ratio? 2:1. And the shares involved in buyback should be fully paid up. Similar to section 55, in case if you are a listed company, follow SEBI regulations. Next one, what is the tenure for completion of buyback? 1 year from the date of special resolution or board resolution. If you are getting, if you need special resolution, then issue notice calling for a meeting. Along with that, issue explanatory statement. In explanatory statement, provide disclosure of material facts. Why buyback? What is the necessity for buyback? What are the shares, shares involved in the buyback? Which class of shares company is going to make buyback? Normal rates or differential rates, and how much amount required for making buyback? And what is the time limit for completion of buyback? Next one, buyback you can choose from existing members on proportionate basis, or you can choose open market, or you can choose employees to whom shares were offered or to whom shares were allotted under ESOP or sweat equity. Can I? Next one, buyback. Before, company has to file a declaration of solvency in SH9 with ROC SEBI. In case of listed companies, SEBI. In case of listed companies, that means both ROC and SEBI. In case of unlisted company, ROC alone is sufficient. And it should be signed by 2 directors. One among 2 directors should be managing director. There is a question. I think multiple choice question or true or false question. Company filed declaration of solvency with ROC, and company is having a Mr. MD managing director, Mr. D director, and Mr. D2 additional director. And this declaration of solvency was signed by D and D2. Whether it is a proper declaration of solvency or improper declaration of solvency, like that a question came for 2 marks. Valida, invalida? Why? Who should sign declaration of solvency? 2 directors, one should be managing director. If company is having a managing director, then 1 managing director, 1 normal director. And it should be supported with a affidavit. And what is the time limit for filing this declaration of solvency with ROC? Before buyback. Time limits, time limits under buyback. First, company will issue a document called a letter of offer to the members within 21 days of filing with ROC. Within 21 days of filing with ROC. That means, with ROC, first we will file letter of offer. Next, we will issue letter of offer to the members. What is the time limit for issue of letter of offer? 21 days of filing with ROC. And offer period is valid for a minimum of 15 days, maximum of 30 days. And for verification of applications under this offer, how much time company is having? 15 days of offer closure. A small correction, what is the time limit for filing a letter of offer? What is the time limit for issuing letter of offer? 20 days. 20 days of filing with ROC. Within 20 days of filing with ROC, issue letter of offer to the members. I told 21 days, just make a correction. It's 20 days. Next one, offer period validity, minimum 15 days, maximum 30 days. That means, during this time period only, members have to submit their application along with share certificates. And verification will be completed within 15 days of closure of offer. If company is rejecting any application, then it is the duty of company to communicate about rejection within 21 days of offer closure. And payment shall be done within 7 days of verification. So limits are very important. First, it starts with filing with ROC. Once filing with ROC is done, within 20 days, issue letter of offer to the members. Offer period is valid. Offer period is for minimum 15 days, maximum 30 days. Once company receives applications, company will start verifying, scrutinizing those documents. And for scrutinizing those documents, how much time company is having? 15 days. If company wants to communicate about rejection, then company is having a time of 21 days of closure of offer. Company is having a time period of 21 days of closure of offer for communication of rejection of application. And company has to make payment within 7 days of completion of verification. Once buyback is completed, within 7 days of completion of buyback, extinguish securities. That means cancel securities. And cooling period, company cannot issue shares involved in the buyback for a period up to 6 months. Even rights also prohibited. But some exceptions are there, in case of bonus shares, in case of conversion of preference shares into equity, debentures into equity, warrants into equity. Next one, sweat equity, ESOPs, in these obligations, yes, company can issue the shares which are involved in the buyback even without completion of 6 months. Even without completion of 6 months from buyback. And once buyback is completed, company is not allowed to make fresh buyback up to 1 year of closure of previous buyback. Listen carefully. Company can buy back its securities. You know, what is the maximum quantum of securities it can buy back? 25%. In the month of April, I made buyback of 5%. How much I am permissible to make buyback? You know, how much, what is the permit limit? 25%. But how much I made buyback? 5%. Now in the month of October, same year, can I make buyback of remaining 20% of equity share capital? Are you getting my point? Students, see, in the month of April, I made a buyback of 5% of equity share capital. In the month of October, I am planning to make buyback of another 5%. Now buyback in the month of October, allowed or not allowed? Answer is not allowed. Answer is not allowed. Once buyback is completed, up to 1 year, company is not allowed to make fresh buyback. Okay. See, at a time that offer shall not exceed 25% of existing capital, existing paid up equity share capital. Even if you select 5% or 10%, after completion of buyback, you have to wait for 1 year. Only after completion of year you can make fresh buyback. That 1 year time gap is between date of closure of previous buyback and date of opening of new buyback. Next one, a register of buyback. A register of buyback shall be in form SH10. Who will authenticate entries in register? Either CES or authorized person. In that register, you will find the details of shares so bought, cancellation of shares, consideration paid, extinguishment, and other material facts. Next one, company has to file a return of buyback in form SH11 with ROC, SEBI in case of listed companies within 30 days of completion. Understood? Along with this return of buyback, yes, company has to file declaration of compliance. Yes, be made buyback by complying all the applicable provisions and rules made thereunder. All the applicable provisions means section 68. We complete section 68 and rules there made under. And this declaration is in form SH15. And who should sign this declaration of compliance? 2 directors. One should be managing director. So 2 declarations we are having. One is declaration of solvency before buyback. Another one is declaration of compliance after buyback. Penalty for default. Company officer in default. What is the penalty? Minimum 1 lakh, maximum 3 lakhs. When you select when you select company profits, when you select divisible profits, when you select securities premium for for buyback of securities, the nominal value of shares so bought back shall be transferred to nominal value. I'm talking about only nominal value. I'm not talking about buyback price. Suppose nominal value, face value 1 rupee. Buyback price 100 rupee. Now how much amount I should transfer to CRR? 1 rupee or 100 rupee? 1 rupee only. Everyone. Next one, nominal value transfer to CRR, and it is utilized only for issuing fully paid up bonus shares. Prohibition of buyback under following cases. If a company is having following defaults, then company is prohibited from buyback. Not only company, its subsidiary company can also its subsidiary company is also prohibited from buyback of company securities. Not only company, not only subsidiary company, but also investment company. If you read section 70, neither company nor its subsidiary nor investment companies can make buyback if company is having following defaults. What are those defaults? Remember types of finance. How many types of finance we are having? Equity, preference, debentures, deposits, term loans. Write all the points. Deposits, deposits interest. Debentures, only debentures. Preference share capital, preference dividends. Term loan, interest on term loan. Term loan is from banks, financial institutions. Next one, dividends here includes both dividends, equity as well as preference. Only one is missing. That one is interest on debentures. So if these defaults are there, missing means what? No need to write. Not there in the provision. Remember these defaults, if any of these defaults are there, immediately rectify those defaults. After rectification, wait for 3 years. And company is also prohibited from buyback if company is in non-compliance with 92, annual returns 123, dividends 127, dividends 129, financial statements. Everyone. So with this, Buyback completed. Last provision of share capital and debentures, that is debentures. So what is the definition of debenture, ma? Debenture includes debenture stock, bonds, instruments evidencing debt. But debenture excludes instruments which were prescribed under chapter 3D, instruments which were prescribed in chapter 3D of RBI Act 1934. Any instrument which is there in chapter 3D of RBI Act 1934, to that instrument section 71 applicable or not applicable? Not applicable. Section 71 is applicable to debenture stock, bonds, any other instrument evidencing debt. And what is the manner of issue of debentures? So first one, company can issue debentures with an option of convertibility. If company selects a convertible option, then special resolution is required. If company selects non-convertible option, then it may be possible with board resolution, it may be possible with a special resolution. Existing debt plus proposed debt, if it is within the limits mentioned under section 180 subsection 1 clause C, board resolution is sufficient. Exceeding the limits, a special resolution. Can a company issue debentures with voting rights, without voting rights? Can a company issue debentures with voting rights or without voting rights? Without voting rights. Debentures shall not carry voting rights. And company can issue secured debentures in case of secured debentures. In case of secured debentures, yes, redemption period maximum 10 years. For infra companies, infra finance companies and permitted companies, the tenure is 30 years. And yes, we need to appoint trustee and we need to create a charge. Either the properties may be on company, holding company, subsidiary company, associate company. Charge is registered in favor of trustee. So charge is possible on the properties of company, holding company, subsidiary company, associate company. Charge is registered in favor of trustee. And MV means market value. Market value of charged assets shall cover not only debenture amount but also interest on debentures. And trustee deed shall be executed within 60 days of allotment. Appointment of trustee shall happen before issue, before offer. Whereas trustee deed shall be executed within 60 days after allotment. DRR, debenture redemption reserve, how much? 10%, applicable to non-convertible portion only to unlisted companies. Everyone, unlisted companies, whether they issue share, whether they issue debentures through public offer, whether they issue debentures under private placement, for all those 10% DRR should be created. And 15% of outstanding debentures maturing in the financial year, that amount you should deposit in specified securities. That means deposits, government securities, notified securities under Indian Trust Act is there. Okay, what is the time limit? 30th April. DRR means keeping profits aside. Investments means some portion of amounts we should invest in these securities. Deposits with scheduled banks, government securities, notified securities. Tell me, can I make any pledge? Can I make any hypothecation on these assets? No. All these things should be unencumbered. The word starts like this: unencumbered government securities, unencumbered fixed deposits. Okay. Next one, for listed companies, for unlisted companies. In case of listed companies, I'll talk about only publicly placed debentures. In case of unlisted companies, I'll talk about both the public placed debentures, private placed debentures. So this 15% concept, investment 15% concept is applicable in case of listed company only for debentures which were issued under public offer. And for unlisted companies, 15% concept is applicable both publicly placed debentures, privately placed debentures. Everyone, sir, publicly placed debentures, how can be unlisted company? I told you many times. Listed company means any of securities listed on recognized stock exchange, but we had few exceptions. Suppose public company whose equity shares are not listed on the stock market, but only non-convertible debentures were listed. I told you, yes or no? Fine. Next one, DRR shall be created out of divisible profits only, and DRR shall be used only for redemption of debentures. Appointment of trustee. Before you appoint trustee, take a prior consent from him, and disclosure of same in the document also required. If you are going with public, or if you are going to offer to members exceeding 500, then appointment of trustee is compulsory. So talking about disqualifications of trustee, the trustee shall not possess following disqualifications. He should not be a beneficial owner of shares. He should not be promoter, director, KMP, officer, employee of cash. Cash means cash only, right? Cash means company associate company, subsidiary company, holding company. A relative of a promoter, director, KMP of the company also disqualified. Creditor, debtor disqualified. But talking about debtor, I will talk about only cash plus SH companies. So debtor of this group companies is disqualified from being appointed as debenture trustee. Next one, surety also disqualified. And a person having pecuniary relationship with a company in the current financial year or in the 2 preceding financial years, then he is also disqualified. Everyone able to follow? Everyone. Next one, in case of removal of trustee, consent of 3/4 value holders is required. And in case of filling vacancy, if it is a casual vacancy, board resolution is sufficient. If that vacancy is arised due to resignation, along with board resolution, consent of majority of debenture holders. Look at the word here, I am telling about debenture holders, whereas here I am telling about value. Value means total quantum of debentures, total value of debentures into 3/4. Here majority of debenture holders means number of debenture holders, number. I'm talking about number of persons here, whereas here I'm talking about value, that means debenture amount. Next one, trustee shall take all steps to protect interest of debenture holders. That means whenever required he may call for a meeting. Whenever there is a requisition from holders holding not less than 1/10 of the debenture capital, debentures, when they make a requisition, then also trustee is liable to conduct a meeting. Liability of debenture trustee. Yes, if debenture trustee fails to exercise reasonable care and diligence, then debenture trustee is liable. Any provision in debenture trust deed exempting trustee from breach of trust, that becomes void. That means any provision giving benefit to the debenture trustee, even though you violate any terms, in case of breach of trust also, you will not get any punishment. Now that clause valid or void? Void. Of course, he will get exemption from punishment. That means he will not get any punishment if there is a consent from 75% of debentures value holders. Can I? Then company has to pay interest and redeem debentures as per the terms and conditions. In case of anticipatory breach, trustee can file an application with NCLT. NCLT may impose restrictions on new borrowings. In case of actual breach, who can also file an application with NCLT? Trustee as well as holders. Either trustee or holders can file an application with NCLT, and NCLT will order for payment of interest, repayment of debentures. Yes, company is bound by specific performance. That means, company made a promise under subsection 8 that company will pay periodical interest and company will redeem debentures at the end of the fixed tenure. Now, company has to fulfill its promises. Next one, powers of central government. Central government can specify the procedure how to secure debentures and in what form trust deed shall be executed, and how to inspect, who can inspect a trust deed, how we can get copies of trust deed, and how much DRR amount we should create, and any other matters. Who will prescribe? Central government prescribes. Everyone. So with this, section 43 to 72, 72 not there, okay, 43 to 72, that is chapter 4, share capital and debentures revision completed. So let's continue our revision with chapter 5, acceptance of deposits. Any company accepting deposits shall comply provisions of Companies Act 2013 and rules made thereunder. So regarding rules, company has to comply Company Acceptance of Deposit Rules 2014. And coming to sections, here we are having 5 sections. 73, prohibition on acceptance of deposits from public. 74, repayment of deposits accepted before commencement of the act. 75, damages for fraud. 76, acceptance of deposits from public. And 76A, punishment for contravention. Okay, so first of all, what is a deposit? Deposit includes any receipt of money by way of deposit, loan, any other form. So the definition of deposit is an inclusive definition. Here we are not defining the word deposit. In fact, we are providing the list of items covered by the definition. So any receipt of money by way of deposit, loan, or any other form, we call it as deposit. But deposit excludes such categories as prescribed after consultation with RBI. So what are those categories? Let's see one by one. Amounts received from the following amounts are not considered as deposits. In that first one, government receipts. Amount received from central government, state government, local authority, statutory authority in the form of loan or in the form of deposit, it is not a deposit as per this chapter. That means chapter 5, acceptance of deposits. So do you think provisions are applicable to these amounts? No. So provisions of Companies Act 2013 regarding acceptance of deposits shall not apply to the following categories. In that first one is government receipts. Next one, foreign sources subject to FEMA, Foreign Exchange Management Act. So amounts received from foreign government, foreign banks, multilateral financial institutions, credit agencies, foreign credit agencies, etc. All those are not treated as deposits. Next one, amounts received from financial institutions. Any loans received from financial institution is not treated as deposit. And any loans received from banks shall not be treated as deposit. Intercompany deposits, company accepting loan or deposit from another company, it is also not termed as deposit. Next one, amounts received from AIF, alternative investment funds, REIT, IIT, infrastructure, investment trust, venture capital funds, mutual funds. These amounts are also not treated as deposits. Next one, following companies, if they are receiving deposits from members, they are not treated as deposits as per this chapter. What are those companies? Nidhi company receiving amounts from members. Chit fund company receiving amount from its subscribers. Trust company receiving amount in the capacity of trustee. Understood? Company is acting as a trustee. Non-interest bearing deposit received by the company as a trustee, it is also not treated as deposit. Next one, collective investment scheme. Amount received by mutual fund companies also not treated as deposits. Next one, securities. By issue of commercial papers, if you are getting money, it is not treated as deposit. Securities application money pending for allotment and failed to refund within 15 days from the expiry of 60 days of receipt of application money is treated as deposit. So that means up to 60 days of receipt of money, it is not deposit. And if you adjust this security application money with any other purpose, adjustment is not treated as refund. Either you have to refund or else we will consider it as a deposit. Suppose if you adjust with any other service expenditure, any other loans, we consider it as not a refund. Accordingly, it will be treated as deposit. Next one, secured debentures, not a deposit. Convertible debentures, not a deposit. Listed debentures, not a deposit. As I told you, secured debentures, the market value of charged assets shall not only cover principal amount but also interest amount. Clear? Everyone. So that means unsecured, non-convertible, unlisted debentures will be considered as deposits. Company receiving money by issue of convertible notes, which type of company? Startup company. Under a single tranche exceeding or equal to 25 lakhs and repayment should be done within 10 years. So any startup company receiving amounts by issue of convertible notes, and if that amount is 25 lakhs or more under a single tranche where repayment is done within 10 years, then that amount is also not treated as deposit. So two conditions to be satisfied. Suppose receiving amount of 15 lakhs, deposit. Receiving 30 lakhs but repayment after 10 years, then also it is a deposit. Two conditions to be satisfied. Single tranche, 25 lakhs or more, repayment within 10 years of receipt of money. Next one, from the following persons, if company is receiving money, then also it is not treated as deposit. One is employee security deposit. Provided security deposit shall not exceed annual salary and company shall not pay any interest on that security deposit. Understood? If deposit exceeds annual salary or if company is paying interest on such a deposit, it is treated as a deposit. Next one, loans from directors. And in case of private company, loan from relatives of a director is not treated as deposit, provided company should receive declaration at the time of taking the loans, accepting the loans. Declaration is about, so the lent money is not out of borrowing funds, out of own funds. Next one, promoter loans, subject to conditions. Unsecured loan because of stipulation imposed by lending institutions. So here, company C Limited went to a bank for getting a loan of, for example, 2 crores. Bank agreed to give loan of 2 crores provided promoters of C Limited should contribute minimum 20%, that means 40 lakhs. As long as C Limited repays these 2 crores, this 40 lakhs is not treated as deposit. Once the loan balance becomes zero, and then if there is any balance due to the promoters, from that point onwards balance due to promoter is treated as deposit. Clear everyone? Until loan balance becomes zero, this 40 lakhs is not termed as deposit. Next one, business advances. Business advances, whenever they become due, refund them within 15 days. Then it is not a deposit. And following business advances are not treated as deposits. One is trade advances, where appropriation happens within 365 days of receipt of money, and advances against immovable property. Next one, security deposit. Next one, long-term project advances. And next one, AMC, EWC, annual maintenance contracts, extended warranty coupons. Next one, sectorial regulator advances. And finally, subscription for publication. So company receiving any amounts under business advances in the following categories, if it is falling under the following categories, then also it is not treated as deposit. But within 15 days of becoming due, refund those monies. Can I proceed? So these all are exempted deposits. That means chapter 5 and rules made thereunder will not apply to these deposits. Can I proceed? Next one, types of deposits. We are having two types: secured, unsecured. Full secured deposits, fully secured, partial security, there is no chance. In case of partially secured deposits, we call them as unsecured deposits. And here security, charge shall be created only on tangible assets, where market value of these charged assets shall cover both principal amount of deposits and interest amount. Can I proceed? So unsecured deposits, whether if they are partially secured, or no security made available, then those deposits are unsecured deposits. Now tell me, disclosure of which type of deposits is required in circular? Disclosure of which type of deposits is required in the circular? If company is accepting unsecured deposits, then disclosure, special disclosure about type of deposit shall be mentioned. Next one, coming to the depositor. Who is a depositor? Any member of a company who made a deposit with company. But if it is an eligible company, then any person who made a deposit. Understood? For section 73 companies, companies can accept deposits only from members, so only members can become depositors. 76 eligible companies, eligible company can receive deposits. Eligible companies can accept deposits from member as well as non-member. So depositor may be member, non-member. Clear? Eligible company, two conditions to be satisfied. First, it should be a public company, and its net worth should be 100 crores or more, or turnover 500 crores or more. Tell me, C Private Limited, a company whose turnover is 1000 crores, whose net worth is 500 crores. Company wants to accept deposits from members as well as non-members. Permitted or not permitted? Permitted or not permitted? Don't look at the limits, look at the type of company. This is a C Private Limited. C Private Limited, automatically it becomes a company under section 73. Section 73 companies can accept deposits only from its members. So under section 73 you will find private companies, and you will also find ineligible public companies. Ineligible public companies. What is an ineligible public company? A public company which is not eligible. Clear? Next one, tenure of deposits. Tell me, can a company accept demand deposits? No. Repayable on demand? Not permitted. So companies are not permitted to accept, to renew. That means, these tenure rules are applicable not only at the time of acceptance but also at the time of renewal. So not permitted to accept renew deposits which are repayable on demand. So that means demand deposits not permitted. Minimum tenure 6 months, maximum tenure 36 months. Understood? And there is an exception to 6 months. For financing short-term requirements, of course, company can accept deposits with a tenure less than 6 months, but it shall not be less than 3 months. And there is a restriction on quantum of deposits. The restriction is 10% of paid up share capital plus free reserves plus securities premium. Can I proceed? Next one, section 73, that is prohibition on acceptance of deposits from public. So here we are having 5 points. I think yes, 5 subsections are there. First subsection, this section is not applicable to 4 companies: banking companies, NBFCs, housing finance companies. Next one, specified companies. To these 4 companies, this chapter, this section not applicable. That means they can accept deposits from public. Tell me, SBI wants to accept deposits from public. Do you think SBI is required to comply with the provisions of section 73? No. Next one, subsection 2. Conditions for accepting deposits from members. First condition, approval of members. Where? At general meeting. Next, proceed with issuance of circular, and that circular shall contain following contents: financial position of the company, credit rating, number of depositors, outstanding number of depositors, and outstanding deposits due. So these 4 these 4 contents should form part of circular, and the circular shall be in form DPT1. And publication in 2 newspapers. One is in English newspaper, other one is in a vernacular newspaper. Yes, both the newspapers shall have a wide circulation. Next one, wide circulation in the place where registered office is situated. Next one, this circular is having a limited validity period. Tell me, how long prospectus is valid? 90 days from the date of filing with ROC. Yes or no? Shelf prospectus is valid for a period of 1 year from date of first public offer. First public offer under shelf prospectus. Now circular is having a validity period. You know, the validity period is 6 months from the closure of financial year, or date of AGM where financial statements are adopted. If AGM is not conducted, then due date of AGM. Out of these dates, whichever is earliest you have to consider. So that is the validity period of circular. Once a circular is ready, copy of circular shall be filed with ROC within 30 days before issuing circular to the members. And company has to create a DRR. And what is the time limit for creation of DRR? 30th April of every year. How much amount? 20% of deposits maturing current year or following financial year? Following financial year. And company is required to obtain a certification from its auditor as to no default. Tell me, a company which has committed default under section 73, is it eligible to accept deposits? No. First, rectification should be done. Next, from the year of rectification, 5 years ban period is there. So that means last 5 years, no default. Even if default was committed, upon rectification, from the year of rectification onwards, 5 years has been lapsed. First of all, there should be no default. If default is there, from the year of rectification, 5 years period shall be lapsed. Understood? So like that, company has to make a declaration. In addition to the declaration, company has to obtain a certification as to no default. Of course, this these points B, C, D, issue of circular, filing of circular, DRR, certification as to no default. These points are not applicable to few companies, few private limited companies. So what are those companies? A private limited company which is accepting deposits up to 100% of paid up share capital plus free reserves plus security premium, or a startup private limited company up to 5 years from date of incorporation, or a private company which has satisfied 3 conditions. One is, it's a company which is not a subsidiary, not an associate to other company. And the total borrowings of this private limited company, borrowings from financial institutions, banks, other body corporates, aggregate all these borrowings less than twice of its paid up share capital or 50 crores, whichever is less. Clear? Next condition, no default in repayment of aforesaid subsisting borrowings. So any private limited company which fulfills these 3 conditions, and a startup company up to 5 years of incorporation, and a private limited company where existing deposits plus proposed deposits put together up to 100% of paid up share capital plus free reserves plus securities premium, then these companies are exempted from above mentioned conditions. Next one, create a charge, charge creation on the assets in case of secured deposits. Can I proceed? And all these companies are required to file DPT3 form with ROC. Next one, so conditions for acceptance of deposits completed. Next one, duty of company. It is a duty of company which accepted deposits to repay those deposits along with interest as per the terms and conditions mentioned in the circular. Any breach by company, any depositor may file an application with NCLT, and NCLT orders company to repay deposits, outstanding deposits, along with the penal rate of interest, which is 18% per annum for overdue period. Next one, DRR shall be utilized only for one purpose. What is that one purpose? Repayment of deposits. DRR shall be utilized only for one purpose, that is repayment of deposits. Next one, maximum how much amount we can accept deposits. What is the quantum of deposits? See, while calculating quantum of deposits, you should not consider only proposed deposits, you should also consider existing deposits. That means whenever I am telling about quantum, existing plus proposed. So what is the limit? Standard limit, it is 35% of paid up share capital plus free reserves plus securities premium. But this rule is not applicable to IFSC public companies. IFSC public companies can go up to 100% of paid up share capital plus free reserves plus securities premium. Suppose paid up share capital is 10 crores, free reserves is 5 crores, securities premium is 5 crores. And existing deposits, I'm talking about specified IFSC companies, existing deposits, it is 6 crores. Now tell me, to what extent they can accept, what would be the proposed deposits amount? Proposed deposits amount, just add it ma. Paid up share capital 10 crores, 10 plus 5 plus 5, that means 20 crores. What is the existing deposits ma? 6 crores. That means proposed deposits, they can go up to 14 crores. Understood? Everyone. And for private limited company also same rule. And these limits, 35% to 100% are not applicable to few private limited companies. One is a startup company up to 10 years from incorporation, from date of incorporation. Just make a correction in your material. For startup company up to 10 years from the date of incorporation. And a private company which has satisfied 3 conditions, that is neither a subsidiary nor associate to another company, and whose borrowings less than or equal to or less than twice of its paid up share capital or 50 crores, whichever is less, and no default in repayment of subsisting borrowings. Suppose company paid up share capital is 10 lakhs. So total borrowings from banks, financial institutions or other body corporates shall not exceed how much amount? Tell me, shall not exceed. It is not shall not exceed. How much amount? It should be less than. Total borrowing shall be less than twice of the paid up share capital. That means here paid up share capital is 10 lakhs. So 2 into 10 lakhs means, suppose total borrowings 21 lakhs ma, or suppose total borrowings 20 lakhs. In both the cases, do you think private limited company fall under this category? No. Private limited company will not fall under this category, because here less than symbol is mentioned. It's not less than or equal to. So in my example, paid up share capital 10 lakhs, definitely borrowings if it is 20 lakhs, so that company will not fall under this category. Why? Because borrowings is equal to twice of paid up share capital, but we need equal to or less than. Can I proceed? And for startup companies up to 10 years from the date of incorporation, there is no limit. Next one, interest rate and brokerage rate. So tell me, can a company pay interest and brokerage according to its will and wish? Yes, but that rate shall not exceed rate prescribed by RBI. Understood? Company is free to fix rate of interest, company is free to fix rate of brokerage, but it shall not exceed rate prescribed by RBI. And company shall pay brokerage only to the brokers from whom company procured deposits. Understood? Understood? So suppose from a broker, total amount of deposits procured by company is 0. Now payment of brokerage to that broker is void. Next one, application form. Application form is required not only at the time of acceptance of deposits, but also at the time of renewal of deposits. Along with application form, declaration about deposits shall be submitted. And this declaration is deposits made not out of borrowed funds. Deposits not made out of borrowed funds. Next one, in case of joint depositors. Yes, allowed, but not exceeding 3. Maximum depositors names mentioned on the deposit receipt is 3. And within how many days a company has to issue deposit receipt? Within 21 days from receipt of money. And for overdue period, what is the penal interest rate? 18% per annum. Can I proceed? Any violation, suppose deposit receipt not issued within 21 days. Understood? So any kind of such violations, company as well as officer in default, fine is 5,000 rupees minimum fine. And if the violation is continuing in nature, if failure is continuing in nature, if contravention is continuing in nature, then 500 per day of during which such contravention continues. Can I proceed? 73 over. You know, in 73, all these points similar to 76. That means in 76 also you will find same points. No change. 76, acceptance of deposits from public. Tell me, section 76, is it applicable to all companies or only eligible companies? So what is an eligible company? It's a public company with net worth 100 crores or more, or turnover 500 crores or more. This or is very important, or else you may end up with writing wrong conclusion. Any one condition satisfied, if it is a public company, then it becomes eligible company. So special resolution is required for accepting deposits. But there is one privilege, one exemption. That exemption is existing debt plus proposed debt including deposits. But debt means not only deposits but also debentures, loans, borrowings, everything will come. Yes or no? So existing debt plus proposed debt, if it is within the limits of 100% of paid up share capital plus free reserves plus securities premium, and in that proposed debt, you know, the proposed deposit is also there. If that including proposed deposit, if it is within the limits of 100% of paid up share capital plus free reserves plus securities premium, then ordinary resolution is sufficient. Or else we need special resolution. After taking special resolution, file a copy of special resolution with ROC. Next one, obtain credit rating. Every year company is required to obtain credit rating as long as company is having deposits. Once deposits repaid, next year if company is not accepting fresh deposits, then no need to obtain credit rating. So that means during the tenure of deposits, during acceptance of deposits, during renewal of deposits, credit rating is compulsory. And creation of charge on the tangible assets if deposits are secured. So yeah, definitely, you know, charge is registered in favor of depositor trustee. So tell me, when a company should have depositor trustee? Before issuing circular. So yes, we need to appoint one or more depositor trustee. Before naming someone as depositor trustee, we need to obtain a written consent from the proposed candidate, and disclosure shall be made in the circular. Yes, we have obtained written consent from so and so person has been named as depositor trustee. Next, execute deposit trust deed in DPD2 7 days before issuing circular. 7 days before issuing circular, execute deposit trust deed. It's an agreement between company and depositor trustee. Now, you know, following persons are disqualified to act as depositor trustee. Who are they? Director of group companies, KMP of group companies, officer of group companies, employee of group companies, disqualified. Not only these people, relatives to these people are also disqualified. Why? Conflict of interest. Independence important, yes or no? Next one, depositor of a company is also disqualified. He cannot act as a depositor trustee. Next one, debtor to group companies, but in group companies you will find another company that is subsidiary of the holding company. Suppose, you know, C Limited is our company, our holding H Limited, our subsidiary S Limited, and our associate A Limited. In the first point, you know, I mentioned 4 companies: H Limited, C Limited, S Limited, A Limited. But coming to third point, here we are also mentioning another company name, that is, you know, subsidiary of holding company. That means our company C Limited and subsidiary of holding company are nothing but fellow subsidiaries. Both are subsidiaries to one holding company. So with respect to debtor, it's not 4 group companies, it's 5 group companies. Next one, any person having material pecuniary relationship with company, he is also disqualified. Next one, surety with respect to deposits or interest thereon. Surety is also disqualified to act as depositor trustee. Hello? Are you there? Everyone? Next, removal of depositor trustee. Consent of all directors present at meeting required. In case company is having independent director, then independent director shall present in the board meeting where resolution has been passed for removal of the depositor trustee. Next point, maximum amount of deposits. So tell me, what is the statutory limit for acceptance of deposits? 35%. 35%, you know, 35% including existing deposits or excluding existing deposits are? Including existing deposits. If you are an eligible company, you can accept deposits from members up to 10% of paid up share capital plus free reserves plus securities premium. From public, you can accept deposits up to 25% of paid up share capital plus free reserves plus securities premium. Listen carefully. Eligible company paid up share capital is 10 crores, securities premium 5 crores, free reserves 5 crores. So total how much? 20 crores. In this on this we need to apply 35%. That means 7 crores. But this 7 crores eligible company, this 7 crores can it accept from members? 7 crores, can a eligible company accept 7 crores from public? No. So how much from members? 2 crores. 2 crores, yes or no? 20 crores into 10%, 2 crores. Whereas from non-members, 20 crores into 25%, that means 5 crores. So that means 2 crores, 5 crores. Suppose from members company accepted 1.4 crore deposits so far. Now proposed deposits cannot exceed 60 lakhs. Everyone. And from non-members, company accepted deposits up to 2 crores. Now proposed deposits shall not exceed 3 crores. Everyone. And for government company, this restriction, this bifurcation is not there. They can accept deposits up to 35% of paid up share capital plus free reserves plus securities premium. Next one, register of deposits. So what is the time limit for making entries in the register of deposits? 7 days from issue of receipt. And who will authenticate entries in this register? Either director or secretary or authorized officer. And how long I should preserve this register of deposits? 8 years from the date of latest entry. That means once you redeem those deposits, once you repay those deposits, you need to enter that statements. You need to make entries in the register. So from the latest entry in the register, we need to maintain these registers for 8 years. That means, in fact, 8 years from the date of latest entry means 8 years from the date of repayment. Are you all getting my point? And in case of premature repayment, 1% rate cut is there. Suppose company accepted deposits with interest of 9%. And in case of premature repayment, 1% rate cut. And this premature repayment rate cut is not applicable in following two cases. One is company repaying deposits in order to reduce deposits to the permissible limits. I told you last year paid up share capital 10 crores, securities premium 5 crores, free reserves 5 crores. So total 20 crores. It accepted 35% deposits, that means 7 crores it accepted. Current year there is a loss. Loss of how much? For example, loss of 5 crores. That means current year closing balance would be paid up share capital 10 crores, securities premium 5 crores, whereas free reserves becomes 0. Because loss, how much loss is there? 5 crores. When you adjust loss with reserves and surplus becomes 0. Now what is the closing balance, ma? 10 plus 5 plus 0, that means 15 crores. 15 crores into 35% means how much? Calculate and tell me. 15 crores into 35%. Maybe 3.5 plus 1.75, 5.25. So 5.25 crores. Whereas company accepted deposits of 7 crores. Now it is the duty of company to return 1.75 crore. So that's the reason, company is repaying deposits prematurely. So reducing deposits to permissible limits, then also rate cut is not applicable. And during emergency situations, rate cut is not applicable. Next one, premature closure to earn high interest. Last year company accepted deposits with rate of interest of 8%. Now company is accepting deposits with 9% interest. Now existing depositor, he want to cancel this deposit and he want to make a fresh deposit under 9%. Possible? Yes. So company will pay 9% rate of interest provided the tenure of deposits shall be longer than the unexpired portion. Suppose last year I made a deposit for 3 years. 1 year completed, that means unexpired portion is how much? 2 years. So for 2 years can I claim high rate of interest? No. I can claim high rate of interest provided I should make a deposit, I should renew this deposit, or I should make a fresh deposit for another 3 years. Another 3 years means which is longer than unexpired portion. Yes or no? So today I am renewing it, for example. So for 3 years means which is more than unexpired portion. Hello? Any meditation? Participation? I think reverse you are telling. Any meditation? Yes, sir. Participation? No. Any confusion? That means whatever I said is clear. Okay, last section, acceptance of deposits. Punishment for contravention of 73 subsection 2 or 76 for company minimum 1 crore or twice of the deposits accepted, whichever is higher or lower. Higher or lower? Lower. So suppose deposits amount is 10 lakhs. 2 into 20, 2 into 10 lakhs means 20 lakhs. 20 lakhs or 1 crore, whichever is less means 20 lakhs. Maximum 10 crores. And for officer in default, imprisonment up to 7 years and fine minimum 25 lakhs, maximum 2 crores. If your intention is to deceive shareholders, creditors, depositors, tax authorities, then punishment under section 447 is leviable. Last point, repayment of old deposits. Here old deposits means deposits accepted after commencement of act or before commencement of act? Before commencement of act. Duties of company. First, company has to file a form with ROC. Within how many months? Within 3 months of commencement of the act. And repay within 3 years of commencement of the act or original due date, whichever is earlier. If you are unable to refund, if you are unable to repay these deposits within this prescribed tenure, then file an application with NCLT for time extension. And any violation, if you are not failing, if you are not repaying those deposits or interest on deposits, which deposits? Deposits accepted before commencement of act. Deposits accepted before commencement of act, any breach regarding repayment or payment of interest, then company 1 crore to 10 crores, that means minimum 1 crore, maximum 10 crores. Officer in default, imprisonment up to 7 years or fine 25 lakhs to 2 crores or both. There is a difference between 76A and 74. 76A is for deposits accepted under this act, whereas 74 deposits accepted before this act. Understood? So the difference is, before this act, minimum fine 1 crore. There is no additional amount like twice of the paid up, twice of the acceptance of deposits. Maximum 10 crores. And here either imprisonment or fine or both. But there imprisonment and fine. And these are the forms we used so far, particularly DPT1 circular, DPT2 deposit trust deed, DPT3 return of deposits. Every company accepting deposits, every company, in fact every company has to file DPT3 with ROC by 30th June of every year. And DPT2, time limit for executing DPT2 is 7 days before issue of a circular. And what is the time limit for DPT1? There is no time limit. If you are accepting deposits, if you want to accept deposits, it is possible only with the preparation of circular in form DPT1. And these are the section numbers as I already told you. Next one, registration of charges. So our next chapter, as I told you, registration of charges, section 77 to 87, and this is chapter 6 of Companies Act 2013. Any company at the time of borrowings, so company may accept, company may accept secured deposits, or company may issue secured debentures, or company may take loans from banks with some security. Now any company creating charge on its assets, it's the duty of company to register charge with ROC, section 77 to 87. See, the logic of this chapter is to prevent companies from taking double finance showing same property as security. Understood? So taking loans from 2 or more parties providing same property as a security. To avoid these situations, registration of charges chapter came into picture. And section number 77 to 87. So remember how to remember section numbers, just look at the screen. First charge, here two types: creation of charge, modification of charge, satisfaction of charge. That means 3 types total: creation, modification, satisfaction, CMS. For creation of charge, yes, for creation of charge 2 parties are required: company, charge holder. Sometimes registration is done by company, sometimes registration is done by charge holder. And next one, any modification of this part, any modification of terms and conditions, any change in parties, company or charge holder, yes, for that also registration of charge is required. So registration by company 77, registration by charge holder 78, modification of charge 79. Whether it is a registration or modification, it will act as a notice. Which kind of notice? Constructive notice, section 80. So once charge was registered, the relevant particulars has to be updated in two registers. One register is maintained by ROC, another register is maintained by company. And in ROC register, you will find creation of charge, modification of charge, satisfaction of charge. Under satisfaction, yes, sometimes company will intimate ROC regarding satisfaction of charge. And sometimes ROC will have inherent powers to make entries for satisfaction of charge in the absence of communication, in the absence of information by company. Next one, appointment of receiver. So ROC register shall contain these particulars: creation of charge, modification of charge, satisfaction of charge. Under satisfaction, intimation by company, powers of ROC, receiver appointment. So company, ROC register 81, and in that register, satisfaction of charge 82, powers of ROC regarding satisfaction of charge 83, regarding appointment of receiver, cessation of receiver 84. And company will also maintain a register, section 85. Any violation of this chapter attracts punishment under section 86. And finally, powers of central government 87. Okay, so creation, modification, satisfaction. For creation 77, 78. For modification 79. Both will act as a constructive notice 80. Register by ROC 81. In that register, you will find creation of charges, modification of charges, satisfaction of charges. Satisfaction of charges are two types: intimation by company, ROC powers. Intimation by company 82, ROC powers 83. And in that register, ROC shall also record entries regarding appointment of receiver 84. And every company has to maintain a register of charges 85. Violation punishment 86. In this entire chapter, central government is having certain powers 87. So first of all, what is a charge? Charge here refers to an interest or lien created on assets of the company or properties of the company or any of its undertakings or both as a security, and charge includes mortgage. So in charge you will find two parties: borrower, lender. Here borrower is company, lender is bank, and lender is also known as charge holder. In favor of whom we are creating charge, it is a charge, he is known as charge holder. Now coming to types of charges, we are having two types of charges: fixed charge, floating charge. Fixed charge is created on specific assets, identified assets, permanent assets. Whereas charge created on fluctuating or changing assets, it is a floating charge. Suppose charge is made on a residential land and building, charge is made on commercial land and building, charge is made on plant and machinery. All these charges are fixed charges. Charges made on book debts, charges created on stocks, all this comes under floating charge. So nature of assets: fixed assets, permanent, identifiable at the time of creation of charge. Whereas floating charge, assets are fluctuating in nature. Floating charge, here charge is not only limited to present assets, it is also extended to future assets. Next one, creation. Fixed charge creation is possible by mortgage or deposit of title deeds, whereas floating charge is created by hypothecation. Next one, asset usage. Assets under fixed charge can't be sold without consent of charge holder, whereas assets under floating charge can be sold in ordinary course of business. And crystallization is possible only for floating charge, it is not possible for fixed charge. And what is the effect of crystallization? Floating charge gets converted into fixed charge. So crystallization of floating charge, whenever creditor enforces security because of breach of terms and conditions by the company, or if company goes into liquidation, or if company ceases to continue its business, in these situations creditor may enforce security, and that process is known as crystallization. Everyone, that means once floating charge got crystallized, company cannot sell those assets without consent of charge holder. Section 77, duty of company to register charges. So here you will see three persons who register charge with ROC. One is company, second one is charge holder, third one is purchaser of charged property, acquirer of charged property. Three parties can register charge with ROC. So first we will see company charge holder. At the time of creation of charge, this charge may be created on tangible assets, on intangible assets, located in India, outside India. But whenever company is creating charge on its assets, it's a duty of company to register charge with ROC. And what is the time limit for registration of charge with ROC? Here we need to see old charges, new charges. Old charges means before, charges before 2nd November 2018. And new charges means charges created on or after 2nd November 2018. For new charges, the time limit is normal time limit 30 days. If crossed, then next 30 days. That means total how many days? 60. If crossed, further 120 days. Further 60 days. That means what is the total time limit, ma? Normal time limit 30 days, additional 30 and additional 60. So total you will find 120 days. But for normal time limit, normal fees is sufficient. For additional time, you need to file an application with ROC for condonation of delay and you need to pay additional fees. And for that period of 60 days, you need to file an application with ROC for condonation of delay. In addition to this, you need to pay ad valorem fees. Whereas for old charges, normal time limit is 30 days of creation. If crossed, then within 300 days of creation. So additional time you will find 270 days. Here additional time is 270 days after expiry of 30 days. Clear? Sir, already 300 days crossed, sir. Then no problem. Within 6 months from 2nd November 2018, if you are able to register charge, then also it is valid only. Can I proceed? Everyone. But in case of belated filings, it is the duty of company to file a declaration. And this declaration is signed by CS or director, stating that there will be no adverse effect on intervening creditors. That means charge was created on 1st January 2025 in favor of A bank. And charge was created in favor of B bank on 2nd February 2025. Same property, no change in property, on a single property, 2 times charge was created. One is in favor of A bank, other one is in favor of B bank. But charge in favor of B bank was registered by 1st March 2025, whereas charge in favor of A bank is registered by 1st April 2025. Are you able to find out the differences, ma? Which charge is first? Bank A charge first. Bank A charge creation first, bank A charge. Which charge is next one? Bank B charge is next one. But coming to the effect, who will get first priority? Bank B. Why? Bank B got rights by 1st March 2025. Whereas Bank A got rights by 1st April 2025. Now rights of intervening creditor in this case is B. So rights of B is not affected due to subsequent registration of charge in favor of Bank A. Everyone. So in case of belated filing, there will be no adverse effect on intervening creditors who acquired rights over charged property before registration of charge in favor of charge holder. Any doubt? Hello? Next one. Section 77 is not applicable to the charges created by banks in favor of Reserve Bank of India. And next one, procedure for creation of charge, procedure for verification of charge instrument. Here you need to check whether property is located outside India or located in India. If it is located outside India, that certificate shall be verified under company seal, director, company secretary, and a person interested in the charge, maybe a beneficial, maybe a owner of the property, and charge holder authorized officer. Whereas property located in India, everything is common, you will not find person interested. That means director or company secretary on behalf of company, charge holder authorized officer on behalf of a charge holder. Everyone. So this is a verification of charge instrument. Next one, section 77 subsection 3 subsection 4. Subsection 1 is duty to register. Subsection 2 is upon receipt of information by ROC, ROC shall issue certificate of registration of charge, and it will act as a conclusive evidence that charge is registered by complying all the applicable provisions and rules made thereunder. Next one, consequences of non-registration of charge. The charge instruments become void. Against whom? Against liquidator and creditor of the company. That means instrument of charge is not enforceable. If charge is not registered, it becomes void. Creditor with unregistered charge shall be treated as secured creditor or unsecured creditor? Unsecured creditor. Talking about validity of debt, tell me, charge instrument becomes void whereas debt is valid. That means debt is enforceable. However, security over charged asset is lost. That means he is losing priority. He is losing preference. If another charge is registered before registration of first charge, then second charge holder gains a precedence over unregistered charge. That is subsection 3 and subsection 4 of section 77. Next one, 78. If company fails to register charge within 30 days of creation of charge, then charge holder is having an option to file an application for registration of charge. Now ROC, straight away he will not issue certificate of registration. First he will give intimation to the company and he will wait for, ROC registrar will wait for 14 days. Within 14 days, if there is no objection from company, then ROC shall register the charge and shall issue certificate of registration of charge. I mentioned here, if there is no objection from company within 14 days of intimation, and ROC will ask a charge holder to get reimbursement of all the expenses incurred by charge holder in registration of charge from company. So charge holder can recover fees from company, normal fees, additional fees, ad valorem fees, whatever fees charge holder incurred, he will get reimbursement from company. But ROC rejects application of charge holder in 2 cases. In how many cases? Case 1, if company is filing form with ROC for registration of charge, or company is providing sufficient cause why not to register charge. In these 2 cases, ROC reject application of charge holder. 78 over. Next, 79, modification of charge. Section 77 is applicable to certain matters like any other company acquiring any property subject to a charge. Now it is the duty of purchaser company to comply with section 77 provisions. I told you example, Reliance Industry Limited mortgaged one property in favor of State Bank of India, and subsequently that property was acquired by V Industries Limited. Now upon acquisition of property, it is the duty of V Industry Limited to register this charge with ROC according to section 77. That means cases in the cases prescribed under section 79, for the situations prescribed under section 79, 77 is applicable. Understood? So section 77 applies in certain matters. One is in case of acquisition of charged property, or in case of modification in the terms or conditions or the extent or operation of any charge. Examples I told you: change in repayment schedule, change in banker, change in rate of interest other than RBI rate. Next one, enhancement of loan facility, or decrease of loan facility, anything, any modification which is an agreement between company and charge holder, the same shall be registered with ROC as if it is a creation of charge. That means modification of charge, provisions regarding modification of charge is nothing but registration of charge which was created earlier. Next one, 80, date of notice of charge. So tell me, from when it will act as a notice? From when charge becomes a public document or charge becomes constructive notice. So date of registration. Charges registered with ROC becomes public documents. Until they get registered, they will not become public documents. Only upon registration it becomes public documents, and it will act as a constructive notice. So effective date of notice is date of registration of charge. Next one, register of charges. How many registers we are having? 2 registers. One is maintained by ROC, other one is maintained by company. ROC maintain register of charges for every company, and any person can inspect upon payment of prescribed fees. And the register here, register is maintained at MCA portal. So documents available at MCA portal will act as a register under section 81. Next one, company, section 85. Registers by company, section 85. Every company which created charge has to maintain a register of charges where at its registered office. All charge documents and copy of charge instruments shall be preserved at register office. Not only register along with register, company has to maintain a copy of charge instruments, mortgage deeds, everything they have to maintain. And who will record entries in the register Director of the company or company secretary or authorized person. And these registers are subject to inspection during business hours by members or by creditors without fees. In case of others, non-members, non-creditors, they need to pay prescribed fees. And how long company has to preserve these registers? Permanently, till the liquidation of company. Whereas instruments related to charge, copy of charge instruments shall be preserved up to 8 years from the date of satisfaction. Very important MCQ. Registers, no time limit. Whereas copy of charge instruments, 8 years from registration or satisfaction. Satisfaction. 82. Company to report satisfaction of charge. It is a duty of company to intimate satisfaction of charge with ROC within 30 days normal time. And what is the extended time? 300 days. Immediately ROC shall send a notice to charge holder and ROC will wait for 14 days. If there is any objection from charge holder, ROC shall record the same and ROC shall forward that cause to the company. But this sending notice is not required if company files an attachment which is NOC issued by charge holder. If charge holder already issued NOC to company and if company is filing that document with ROC, then ROC will not intimate anything to the charge holder. So upon satisfaction, upon filing of this information, ROC issues certificate of satisfaction of charge. And ROC shall enter the details in his register. Memorandum of satisfaction entered in the register maintained by ROC, which is section 81. Next, 83. Power of ROC to make entries of satisfaction and release in absence of intimation from company. In what situation section 83 applies? If there is any evidence proving that debt secured by charge is wholly or partially satisfied, company paid debts, or charged property is released from charge. Charged property or charged undertakings are released from charge. In that case, yes, section 83 comes into the picture. So what is the power of ROC? Power of ROC is independent. It is not subordinate to some other parties, independent, and it is not affected by company's failure to notify intimation of charge. And ROC, upon making entries in the register, memorandum of satisfaction of charge in the register, so ROC shall intimate to the affected parties, that is company as well as charge holder, within 30 days of making entries in the register maintained by ROC. And finally, registrar issue certificate of satisfaction of charge. 83 also over. Hello. 84. Intimation of appointment of receiver or manager. Last 2 minutes, just concentrate. Intimation of appointment of receiver or manager. Applicability. When this section is applicable, any person obtains an order for appointment of receiver or manager to manage charged property, or any person appoints a receiver or manager under the charge instrument. If that fellow is getting an order from the authority for appointment of receiver or manager, or if that fellow is appointing a receiver or manager under instrument, both the situations or in any one of the situation, that person has to intimate company as well as ROC. Within how many days? Within 30 days of the order or within 30 days of the appointment. And what's the ROC's action? ROC register particulars in the register of charges maintained under section 81. And in case of cessation also, the person is responsible to notify ROC as well as company. And what ROC will do? ROC shall register the same in its register. 84 completed. 86. Punishment for violation of this chapter. Company 5 lakhs. Officer in default 50,000. And in case of willful omission of information while filing with ROC or filing false statements with ROC, so both the cases punishment is 447. Person responsible for fraud 447. Next one, rectification by CG in register of members. Section 87 applies in following two cases. One is company failed to give intimation of satisfaction of charge within the prescribed time limit, that is 30 days or 300 days. Time limit over, company failed to intimate ROC regarding satisfaction. Then company will make an application to central government. Second situation, omission or misstatement of particulars in the previous filings regarding creation of charge, regarding modification of charge, regarding satisfaction of charge. Any filings with ROC, in those filings, if there is any false information, or if there is any omission of particulars, in these cases also, company shall file an application with CG for rectification. Now, CG will pass an order provided CG is satisfied that the default was accidental, unintentional, not intentional, or the default will not have any negative impact on creditors, shareholders position. Then central government will pass a rectification order. But central government will not pass this order on suo motu. Central government will pass an order only when an application is filed by company or interested person. So application by these people, situations, conditions and result. At last, CHG 1 for registration of charge other than debentures. CHG 9 registration of charge for debentures. CHG 2 for charge registration certificate. CHG 3 certificate of charge modification. 1 and 9 are the filings by company, and 2 and 3 certificates issued by ROC. CHG 4 form for satisfaction of charge. This is also like company filing with ROC, and and ROC will issue a certificate under CHG 5, form CHG 5, memorandum of satisfaction of charge. CHG 6 is for appointment or cessation of receiver. CHG 8 for application to central government. 87 I told you, right? Application by company or interested person to central government. It is in form CHG 8. Next one, last one, CHG 7, register of charges to be maintained by company. So registers in which format? CHG 7 format. So with this, registration of charges also completed.